Yang Arif Datuk Sri Haji Muhammad Abandi bin Ali, former office bearer of the bar as well. Yang Arif Datuk Zahra binti Ibrahim, Yang Arif Datuk Azhar bin Muhammad. Professor Arif Freeberg, members of the Royal Malaysia Police Force, members of the Attorney General's Chambers, bar and public. Today's dialogue on establishing a sentencing council is topical, given the public scrutiny and media comments on recent sentences which are perceived to be inconsistent and disproportionate to the seriousness of the offence. We have experts from within Malaysia, a senior appellate judge and a senior practitioner, and from abroad, a chairperson of 2 sentencing councils, to demystify and clarify the complexities of sentencing whilst seeking to examine and educate the objectives and the process of realization of these objectives of sentencing in the courtrooms of Malaysia. Justice Wan Yahya, as he then was in the case of Hari Ram Segal against public prosecutor, correctly described the objective of sentencing when he said, and I quote, "Our courts have a long time since progressed from the eye for an eye and tooth for a tooth type of justice. The avowed aims of punishments are retribution, justice, deterrence, reformation, and protection. But it is never intended to act as a vehicle of vengeance. This court does not sit here to hand out to victims of aggression their pound of flesh, but generally to protect society by enforcing justice. It is almost universally accepted that the 4 aims of sentencing are retribution, deterrence, rehabilitation, and incapacitation. And finding the right balance between the 4 aims is never easy. In attempting to achieve these aims, the established judicial principles of sentencing include that the court shall pass a sentence that is proportionate to the offender's degree of culpability and consistent with other sentences of similar offences. Consistency and proportionality of sentencing are the 2 most difficult aspects of sentencing, and as both history and recent events demonstrate. One comprehensive approach to resolving this difficulty is the establishment of a sentencing council, which would promote consistency by having guidelines for judges to decide on the appropriate sentence to reflect the crime committed and proportionate to the seriousness of the offence. The sentencing guidelines for individual offences set out sentence ranges, reflecting different levels of seriousness, and within each range, a starting point for the sentence. The guidelines also provide guidance on factors the court should take into account that may mean a more or less severe sentence should be imposed. A sentencing council is meant to be an independent body responsible for developing sentencing guidelines in consultation with stakeholders, monitoring the application and use of guidelines, assessing a wide range of decisions relating to sentencing, educating the public about the process of sentencing, and undertake research on the more complex questions of law on sentencing and survey of public expectation of sentencing. Sentencing guidelines are what they say they are, guidelines, and they're not meant to be mandatory. If there's any error in sentencing, it is for the appellate courts to correct it and not the sentencing council, which plays no role in the court process save to provide these guidelines. Judges do recognize that sentencing must be consistent with legitimate community expectation, otherwise public confidence in administration of justice will be eroded. A sentencing council will engage the public, and this will reduce misunderstanding amongst the public, increase understanding on the part of judges of public expectation. Instead of eroding confidence, this process will increase public confidence. The composition of council should include judges, prosecutors, civil societies, defense lawyers, and academics. The Malaysian Bar welcomes the government's 3 proposals of law reform involving sentencing. Firstly, we are encouraged by the Honourable Minister's announcement that the government is agreeable in principle to the establishment of a sentencing council. Secondly, the proposed amendment to the Dangerous Drugs Act 1952 to give judges the discretion of not imposing death sentences on couriers, and one of the suggestions is to allow those on death sentences to be re-sentenced. This means that those on death row will be referred back to the courts with legal representation to be re-sentenced. Thirdly, the Honourable Minister is leading a cross-party initiative to end the use of death penalty. An initial step being considered is to scrap the death penalty for drug offences and moving the Malaysian Cabinet to defer the death sentences passed on 675 convicted drug traffickers in the country, while the government reviews the death penalty for drug offences. Such a moratorium, if imposed, puts Malaysia towards the right path of abolition in due course. I wonder if the Honourable Minister could persuade the Honourable Prime Minister to make abolition of death penalty as part of the PM's campaign manifesto. There is precedent for this. When François Mitterrand campaigned for presidency of France in 1981, the abolition of death penalty was part of his campaign. And when he became president of France, France abolished the death penalty. And if you can bear with me, part of Mitterrand's campaign on the death penalty included this passionate plea, and I quote, "As with the other issues, I will not hide my views on the death penalty. And I have no intention of going to the country in this race and pretend to be something I am not. In my innermost conscience, like the churches, the Catholic Church, the Reformed churches, Judaism, and all the important national and international humanitarian associations, in my heart of hearts, I'm opposed to the death penalty. I'm standing for the presidency of the French Republic, and in asking for a majority of the French people's votes, I do not hide what I think. I say what I think, what I hold to, what I believe in, and what my spiritual beliefs and concern for civilization are based on. I am not in favor of the death penalty." The question of sentencing, end of quote, the question of sentencing should always ultimately be left in the hands of our judges. We rely on their experience in hearing cases and in being familiar with the facts and circumstances of each case that comes before them. With the recent amendments to the Criminal Procedure Code that have introduced victim impact statements, namely reports on the effect that a particular crime has had on its victim, our judges are now better placed to dispense justice in a more comprehensive manner, taking into account all the circumstances of the case. This respect for the discretion of the judge is one of the reasons why the Malaysian Bar welcomes recent public statements by various parties calling for the abolition of the mandatory death sentence for drug-related offences. Apart from questions relating to the efficacy and effectiveness of mandatory death sentences as a means of deterrence, the resort to mandatory sentences is an unnecessary factor on the discretion of the judge and an unwarranted impediment to the free flow of justice. It thus comes as a sad and significant departure from this sensible approach recently taken by the government that this judicial discretion is to be removed in cases of sentencing for statutory rape. The recent controversy surrounding its use in two recent cases cannot in and of itself be the reason for the proposed amendments to exclude the applicability of Section 294 of the Criminal Procedure Code in cases of statutory rape. If my ability as an advocate were to be judged by my success rate in persuading the Honourable Minister of the various positions of the Bar, then I admit I'm a poor advocate, and this issue is one of my failures. However, I take this opportunity to urge the Honourable Minister to reconsider this decision based on my arguments. I'm confident that the outcome of this dialogue will be greater momentum towards establishment of a sentencing council in Malaysia, and I hope everyone will take the opportunity to inquire whether this is indeed the comprehensive answer the Bar says it is. The Bar thanks the Honourable Minister for officiating this dialogue, the Chief Justice for supporting this dialogue, and the Honourable Attorney General and Inspector General of Police for sending his officers to attend this dialogue. Thank you.
Thank you, President of the Bar, Mr. Lim Ji, for your insightful speech. Ladies and gentlemen, distinguished guests, it is now my pleasure to invite the Minister in the Prime Minister's Department, Dato Sri Muhammad Nazri bin Tan Sri Abdul Aziz, to give his opening remarks and speech. Nazri.
I think your rostrum is not speaker friendly.
How do I put the left of the yes. Wait, move the left.
Assalamualaikum warahmatullahi wabarakatuh. Salam satu Malaysia. Amrit, our chairperson this morning, the Honourable Dato Azhar Muhammad, Judge of the Court of Appeal, together with Dato Zahra bin Ibrahim, and also Dato Effendi. They were all my colleagues and still my colleagues. Professor Ari Private, Chairperson of the Victorian Sentencing Advisory Council and Tasmanian Sentencing Advisory Council. Members from the AG's chambers, from the police, the bar, and members of the public. Before I begin, I wish to take this opportunity to thank the Malaysian Bar Council for again inviting me here today to deliver this address. I am deeply honored by this invitation from the Bar Council. I also wish to congratulate the Malaysian Bar Council for its initiative to organize this dialogue session which brings together experts in this field and all related parties such as the Judiciary, the Attorney General's Chambers and members of the Malaysian Bar to discuss proposal to establish a sentencing council in Malaysia. As we all know, the idea of sentencing council is not a new one, as it has been implemented in other countries, such as the United States of America, in Australia, especially in New South Wales and Victoria, and also England and Wales. In Malaysia, as we have yet set up a sentencing council, sentencing is at the absolute discretion of the courts, which perform this responsibility in accordance with its judicial wisdom. For purposes of check and balance of sentencing practices, the superior courts have been empowered to revise or review decisions of lower courts which are not appropriate. Now, it is hoped that the establishment of a new sentencing council will reduce the necessity to revise or review sentences meted out. I firmly believe that a dialogue session as the one organized today will be beneficial for us, for all of us, to rightly understand the actual implementation and implications of sentencing council, as the time is now right for Malaysia to seriously consider the setting up of a sentencing council to enhance the administration of justice. Ladies and gentlemen, the general purpose of establishing a sentencing council is to reduce the disparity of sentences meted out by the courts, while at the same time respecting the independence of the judiciary. The sentencing council should only serve an advisory function and should not be viewed as a body designated with powers to review the decisions of the court. I wish to repeat this again. The sentencing council should only serve as an advisory function and should not be viewed as a body designated with powers to review the decisions of the court. As practiced in some countries, a sentencing council develops guidelines to assist judges in the practice of sentencing. Ladies and gentlemen, there are many reasons we can think of in deciding to set up a sentencing council. But first and foremost on our mind will be to reduce the disparity of sentences among courts of concurrent jurisdiction. The objective of sentencing is to ensure that justice is provided to all, including the victim and perpetrator of a crime. The sentence should be appropriate to the crime committed. With this in mind, it is acknowledged and accepted that there cannot be fixed sentences in respect of a crime, and courts are given the flexibility to determine the appropriate sentence, taking into consideration the facts and circumstances of the case, as well as the mitigating and aggravating factors in each case. However, the differences in sentences meted out should not be of such disparity so as to erode public confidence in the criminal justice system of our country. Although legislation do provide for the punishment that could be meted out in respect of the offences committed, the meting out of appropriate punishment is not an easy task. The heavy burden on the court is best summed up by Dato' Ho Moi Ching in her book entitled Sentencing Practice in Malaysia, where the following was quoted. Quote, "In the Malaysian context, where no sentencing guidelines are issued by any authority, and there is a paucity of guideline judgment, sentencing can be a most challenging task facing the criminal court. More so when the sentencer is inexperienced and has little access to resources, as magistrates in outlying magistrates' courts often are." Unquote. With a sentencing council in place to provide guidelines for sentencing, a more consistent sentencing practice can be formed, and this will promote greater public confidence in the criminal justice system. Public opinion is important, and the judiciary should play its role to ensure that public confidence in the administration of justice is maintained. I wish to humbly quote the decision by Justice McHugh in the case of Macarian versus the Queen, year 2005, 215 ALR 213, where the following was observed. Quote, "Public responses to sentencing, although not entitled to influence any particular case, have a legitimate impact on the democratic legislative process. Judges are aware if they consistently impose sentences that are too lenient or too severe, they risk undermining public confidence in the administration of justice and invite legislative interference in the exercise of judicial discretion. For the sake of criminal justice generally, judges attempt to impose sentences that accord with legitimate community expectations." Unquote. Sentencing council thus can play a role in forging a link between the views of the general public and the decisions on sentences made by the courts. Ladies and gentlemen, the establishment of a sentencing council, therefore, will function to reduce the disparity in sentencing by providing guidelines to assist the courts in deciding on the right sentence. I am of the opinion that with guidance from the experts and also from the study and research that is being conducted into this matter, a meaningful outcome can be gained for the benefit of everyone. It is my hope that the dialogue sessions being conducted for the next 2 days can shed light on what we can foreseeably expect with the establishment of a sentencing council and how it can assist in the administration of justice to further enhance the protection of the rights of every person in Malaysia. With this in mind, I wish all of you the very best, and I look forward to a very productive return from the sessions planned over the next 2 days. Thank you.
Thank you, Yang Berhormat, Dato' Seri Muhammad Nazri bin Tan Sri Abdul Aziz, for your very encouraging speech. Distinguished guests, I now would like to invite Mr. Lim Chi Wee, who will present a souvenir to Yang Berhormat Dato' Seri Muhammad Nazri bin Tan Sri Abdul Aziz, Minister in the Prime Minister's Department, as a token of appreciation. We wish to thank Yang Berhormat Dato' Seri Muhammad Nazri for graciously opening and attending this dialogue.
Yes, certainly.
Thank you, Honorable Minister and Mr. Lim Chi Wee. I'd like to inform members of the press and media that Honorable Minister and Mr. Lim Chi will be giving a press conference at level 3 soon. Now, I think now, yes. Thank you again, Honorable Minister. Distinguished guests, we are about to commence our dialogue. And first on the agenda will be a talk by Professor Emeritus Ari Freeberg. Professor will be presenting two topics, namely, firstly, sentencing advisory councils, bridging the gap between the community, the courts, and the government. And the second topic would be promoting consistency in sentencing. Before we invite Professor Emeritus Ari Freeberg, let me illustrate a little background of Professor. He was a Dean of the Faculty of Law at Monash University between 2004 and 2012. In 2009, Professor Ari was made a member of the Order of Australia for his service to law, particularly in the fields of criminology and reform related to sentencing, legal education, and academic leadership. His particular areas of expertise include sentencing and the administration of criminal justice. He has served as a consultant to the federal, Victorian, South Australian, and Western Australian governments on sentencing matters, as well as the Australian and South African Law Reform Commissions. In 2002, he completed a major review of sentencing for the Victorian Attorney General, published as Pathways to Justice. In July 2004, he was appointed chair of the Victorian Sentencing Advisory Council, and in February 2013, he was appointed chair of the Tasmanian Sentencing Advisory Council. He is a member of the Council of the Australian Institute of Judicial Administration. Professor Ari Freeberg has around 130 publications in areas such as sentencing, confiscation of proceeds of crime, tax compliance, corporate crime, juries, juvenile justice, sanctions, victimology, trust in criminal justice, fraud and trust in criminal justice, commercial confidentiality in corrections, dangerous offenders, the role of emotion in criminal justice and public policy, drug courts, problem-oriented courts, non-adversarial justice, and regulatory theory. With that, just 1/3 of it, and when I met Professor Ari early in the morning, and I told him, if I start on your biodata, Professor, it will seem that I'll be giving a speech here myself. So he's agreed to the condensed version, and with that, let's meet this fine gentleman. Professor Ari, please.
Thank you very much, President and members of the Bar. Perhaps I will have a condensed version of my introduction by saying distinguished guests. All of my predecessors this morning have mentioned everybody by name, and my pronunciation will probably offend somebody. And so I think you're all distinguished, and I'm very happy and honoured to be here today, to be invited here to Malaysia to participate in this dialogue on the establishment of a Sentencing Advisory Council. In the report that I prepared for the Victorian Attorney General in 2002, Pathways to Justice, one of the terms of reference there related to the establishment of a Sentencing Advisory Council. And I'm pleased to say that that was adopted by the Attorney. As you've heard, in 2004, I was appointed the inaugural chair of the Council, which has now been in existence since that time. I'm particularly pleased to have been recently appointed to the chairmanship of the Tasmanian Council. I think I now hold the world record for chairing Sentencing Advisory Councils, 2 at the same time. There you are. Not in the Guinness Book of Records, but something I'm particularly pleased by. My presentation this morning will give you a bird's eye view of some of the issues that you will confront and need to discuss in the establishment of a Sentencing Advisory Council. I can't say how pleased I am that this dialogue is occurring, because having been a proponent and participant in the establishment of these, you have no doubt of where my sympathies lie in the importance of such a body in any justice system. The presentation this morning will be in 2 parts, and we'll take a 5-minute break to allow you to wake up and get some air, because there are in fact 2 parts of this. One is about the Sentencing Advisory Council in Victoria, and secondly, mechanisms more broadly to deal with the problems you've heard about this morning about unwarranted or unjustifiable disparity. They're 2 enormous topics. We could take days to discuss them, but you have the slides, and there can be I can provide some supporting documentation in relation to each of these. I understand that the question time will take place this afternoon as part of the general discussion that will take place with other speakers. So let me give you a helicopter view of some of the issues and discuss how it might fit in Malaysia. Can I stress right from the beginning that any decision made about the establishment of a council in your country, or in any country, is how important it is to make it appropriate and responsive to your particular judicial system, to your particular political system, to your particular requirements, and to particular problems that you have in your country. The worst thing possible is to copy somebody else's council without a clear understanding of what your problems are, your context, your resources, and your issues. And every council that's been established has been unique in its environment, and that's very, very important. I suppose the first question, and we've heard part of the answer this morning, for some reason it hasn't changed on there. Okay, thank you very much. I should change both, I think. What are the problems to which a council is the answer? It's all very well to have a council, but we've heard one of the problems this morning, and that's one that I think is endemic and consistent across all jurisdictions, and that is unwarranted or unjustifiable disparity. I'm going to come back to that later this morning. But when we have a look at the Victorian Council, and this is on our annual report, there are a number of needs, a number of requirements, a number of problems to which a council can be the answer. One is the need for accurate and credible data on sentencing. That is, what do the courts actually do? How much does the bar, how much does the profession, how much does the public, how much do politicians know about what sentencing outcomes are? That is, what information is available to the profession and to the public generally on sentencing data. How much do you know what the courts are doing? How much do the courts know what each other is doing? A second problem is that there is a perception that sentences are inconsistent or otherwise deficient. Well, we've heard the press publicity surrounding 2 cases, and it's almost always the case that it will be some highly publicised case in the newspapers that will throw open the problems. In fact, the very first case that we got before the council, our very first reference related to a sentence for rape, where an offender got a suspended sentence 30,000 people marched on Parliament House and said this sentence is inadequate. There was a great deal of anger. The first response of the Attorney then was not to legislate straight away, but to send it to the Council. It was our very first reference on suspended sentences. So it's often the case that some highly publicised event will stir up public emotion, public concern, and it's precisely in those cases that you need a calm and considered response rather than a knee-jerk reaction. There's a perception that sentencing laws are deficient and that there's something wrong, you found some loophole. There's a low level of public knowledge about, but a great deal of interest in sentencing issues. There's sometimes a perception that the courts, rarefied, sitting out somewhere, are out of touch with the community, whatever we think the community thinks, and this is another issue I'll come back to, what community attitudes actually are versus how the community attitudes are portrayed in the press or on the radio or on television. They're not the same. And importantly, when we talk about the development of sentencing policy, the opportunity of the community to have a say in sentencing. It's not just a role for Parliament and it's not just a role for the courts. Sentencing is of community interest and in the development of public policy. Not in the development and not in the imposition of sentences in individual case, but in the development of sentencing policy, there is a real and important role for the public to be involved in voicing their views and in making their attitudes known. So, sentencing councils, as you've heard, have existed since the late 1980s, and they were pioneered in the UK with the Sentencing Advisory Panel, which existed for 12 years. It then had an overlap with the Sentencing Guidelines Council, and then there is now one body, sensibly, the Sentencing Council of the United Kingdom, and that's the one that's in operation now. I'll come back to that in a moment. In Australia, it was New South Wales that pioneered the establishment of councils. Victoria had one in 2004. Queensland had one for about 18 months. Sadly, when a new, very conservative government was elected in 2012, one of its first acts, about 3 weeks after it was elected, was to abolish the council. I think, not unfair to say, that it was not particularly interested in having independent advice. It may not have liked the advice received very briefly in its life and just peremptorily abolished the council. I won't make any more political comments there, but you can guess my views on that. Tasmania established a council. This council, which I have just taken over the chairing, has one full-time staff member. So, as you'll see, councils vary. The council itself has 10 members, but the support is 1 member. So, large difference between the councils. South Australia has set one up. I can't find any details about that other than an announcement that's been set up. And Western Australia, as part of the current election campaign, the opposition has promised one to watch over the judiciary. As you know, we don't listen to anything that's said in the course of an election campaign. I gather there's an election here, but I won't say anything there. But all I can say is Western Australia is using this as an election issue. South Africa proposed one. It never went anywhere. New Zealand had probably one of the best and most comprehensive set of guidelines ever established. It was about to have a sentencing council. All the members were nominated. A new government came in and failed to set it up. So there you had a situation with a great set of guidelines, but no council. Got nothing at the moment. So that was an interesting development. Scotland had one for 3 years. The US has got 24, the most famous being the federal guidelines, which are the Sentencing Commission, which are very prescriptive, mathematical, statistical guidelines, which nobody else in the world particularly likes or follows. And Ireland is about to get one, and I'll come back to that in a moment. So let's have a look at some of the broad issues that I think you will have to confront as you work your way through the dialogue. And I do stress this is really important. It's great to have a discussion. Wonderful to see so many people from so many different backgrounds here. To have a discussion about what your council, should it be set up, looks like. The first issue you have to think about, is it going to be a statutory council, that is one under an Act of Parliament, or administrative, that is one set up through some administrative or just governmental sphere, if you like, under the Department of Justice. The Victorian Council is a statutory council. We are appointed by the Governor in Council and can only be removed by the Governor in Council or by Parliament, and that gives us a certain amount of independence. I think that's very important. Tasmania is just set up at the behest of the Attorney General. New South Wales has an Act of Parliament, and in England it's under the Coroners and Justices Act. So my preference, for what it's worth, is that if you embed it in legislation, its independence can be more guaranteed than if it's just a body that's set up by the Attorney General. Having said that, there's nothing to stop a government from abolishing it as they did in Queensland. The question is then, who appoints it? Is it the executive? Is it Parliament? Are there elections for membership? Are there calls for nominations? Originally our council and many others, there's a call for nominations. The usual way is for the executive to appoint people, often after expressions of interest, but it's often you have categories of membership which have to be met and fulfilled. The terms of reference vary widely between various councils. I notice here that the major discussion relates to guidelines. It's one of the mechanisms for dealing with unwarranted and unjustifiable disparity. Can I say this is only one of the many functions that a council may have, and in fact the Victorian Council, while it has a remit in relation to guidelines, and as I will mention in a moment, has never advised on any guideline, because the judiciary, the High Court, and many judges and many courts are vehemently opposed to guidelines at all because of the restrictions they see being placed upon their discretion. So in some places you have councils whose sole job it is to promote or issue or advise on guidelines, like some of the United States councils. We have a council without guidelines, and whenever I speak about this, there's some degree of bemusement. What does a council do if it doesn't do guidelines? Well, there are other things that councils can do. It can advise governments on law and policy. It can assist in gauging public opinion. It can have a role in educating the public. It can collect and analyse statistics. It can conduct research generally and consult with the government, the public and interested parties. So can I just stress that guidelines are not the only mechanism to bring about consistency. I'll be talking about that in part 2. And secondly, that guidelines are not the only role for councils. I see them as having a far greater, and if I may say, far more important role in the public debate on sentencing. So my second plea to you is, do not become too focused, I won't use the word obsessed, by guidelines, because there will be continuing dialogue between yourself, the judiciary and Parliament about the role and the bindingness and the nature of guidelines, but I urge you to take a very broad view about the role of a council in your society. The next issue is, who do you want on the council? How big is it going to be? The judiciary clearly play an important role, and what's important there is the number of people on your council. We have 15, Tasmania has 10. It's usually round about between 10 and 20. I'm sorry, yes, this one. That's it. I've got 2. I'll watch it. Okay. The judiciary, the number, the balance, who chairs the council is very important. I can say as chair of 2 that the role of chair is very important in driving the agenda, in being the public face of the council, in talking to governments. The English Council, chaired by judges, New South Wales, chaired by ex-judges. Victoria has no members of the judiciary upon it. But the nature of the work of the council will be very much determined by who chairs it and what the balance is between the judiciary and others. Again, I will come back to that later on. Whether you have victims on the council, I heard you mention this morning that you now have victim impact statements. This is something that's been developed for a long time in other jurisdictions. The number and role of victims on a council, I think, is very important. You must, I think, or we must see sentencing as a broadly based exercise which involves the state, that is the government, the judiciary, and members of the public and victims. It's not just to do with what happens in the courts. I can't stress that enough. Sentencing is a public exercise. It's not just what judges do. Judges are part of a broader system, a broader public system of sentencing, which involves Parliament, which involves the judiciary, involves the executive, corrections, ultimately involves police as well in the development of law enforcement policies. So, members of the community, members of the prosecution, defence lawyers, police, people with experience in the criminal justice system, academics, people from corrections. All of these are important, relevant and interested people in the criminal justice system. So I suppose point number 2 is that I would say look at a broad and inclusive council. I can't stress to you the discussions we have around the table in Victoria are informed by the range of views, and that enables us to be able to balance our views and come to outcomes which represent or summarise or epitomise the views of a broad range of people. And I think in that way our recommendations have more credibility than if it were just all judges or if it were just all police. I'm looking at our police member, or if it were just lawyers. Heaven forbid it should be just lawyers. Even academics have a role to play. The other important point is whether people are on the council in a representative or personal capacity. Again, my strong belief is that people should be there in a personal capacity. That is, you may be a member of the bar or the bar council or the defence bar or the judiciary or the DPP or whatever the prosecuting, but you are there because you have that experience and knowledge. If you are there to say, my council says, my department says, correction says, then you are locked in to a position which you yourself may not share, but importantly, may not be the best view for the circumstances. It's always possible to get the views of your department or the DPP or whoever you not represent come from. But what's important around the table is to say, what do you think, bringing your experience as a police officer, your experience as a defence lawyer, your experience as a judge, not this is what I'm told by the Chief Justice, not I'm told by the Director of Corrections. You are there because you are a person who can bring something to the table. So, again, you're getting my views on this. Further issues that you have to confront, and this is an agenda that you will have to work through, and it's a difficult one. One is, what's the relationship between governments and the judiciary? Now, I don't have to tell this audience about the rule of law and the enormous importance of the independence of the judiciary. I don't think that's a matter for debate. The independence of the judiciary is taken for granted. What is important, however, is to understand that governments, of course, have a role in sentencing. They set the framework. They create mandatory sentences or presumptive sentences. They create corrections. They give you the options that are available to you. And ultimately, in a democracy, it is Parliament that will have the final word. If they don't like the decisions, they can overturn them, in a sense, by legislation. But ultimately, the decisions about sentencing, I believe, should be left to the judiciary, an independent judiciary. The importance of consistency in sentencing, the issues of leniency and transparency. What's important there is what can the council bring to assist these aims. Public confidence in the courts is very important. If 30,000 people are marching in the streets, as has happened, if the newspapers are up in arms, if people don't believe the judiciary is imposing appropriate, proportionate and consistent sentences, they will look elsewhere, often to Parliament, to step in and bridge the gap. I don't think that's necessarily the best way to go, but as we heard from that quote from Justice McHugh in Macarian, public confidence is the bedrock in any democratic and judicial system. The other thing is the public is not just a remote player in terms of consultation, in terms of membership of the council. Getting the views of the public is an important part in that legitimacy. Finally, I'd want to make the point that although governments don't necessarily like to hear it, and although courts don't necessarily like to hear it, having a source of independent advice and information, painful though it may be, I think is the essence of good public policy. And in Victoria, can I say, my touchstone of independence has been that we have upset every arm of government at some time. So I reckon that's a good job. You're not going to please everybody at any time. If you do, you're not being independent. So I don't know whether you like that as a particular KPI, but independence does not mean you're trying to please everybody. You give the best advice possible. So let's have a quick look at some of the councils. The mother or the parent of all councils, I don't want to be gender biased here, the parent council. Again, the stress here is on consistency in sentencing while maintaining the independence of the judiciary. We're all aware of the importance, the role of the judiciary, and this is not about imposing, impinging, constricting the independence of the judiciary. The council in England is focused mainly, but not exclusively, on producing guidelines. And recently, quite interestingly, and I think as a result of some of the work that's been done in Victoria and elsewhere, aims to increase public understanding of sentencing. It started out as a guidelines council. It's broadened its remit in the last few years. You can see, and I won't go through the details there, of the 2009 statutory remit. Again, first and foremost for them, sentencing guidelines. Interestingly, they have to publish the resource implications. It's all very well to say we're going to increase the sentences from X years to X plus 5. What's that going to mean for the jail population? What's that going to mean for probation? How much is it going to cost? And this is an important factor. You can't do it in the abstract. They're saying if you want to increase it from X to X plus 5, and you're going to end up with 5,000 more people in prison, who's going to pay for that? What is it going to cost? Prisons are not free, and prisons are very expensive, as well as being ineffective. So to monitor the operation of its guidelines, prepare a resource assessment, promote awareness of sentencing and sentencing practice, and publish an annual report. So that's the UK. And interestingly, in doing that, it has to have regard to the sentences imposed, and for that you need information, you need good sentencing data. The need to promote consistency. We come back to this again and again. Consistency is the keynote, and later this morning I'll be talking about this tension between the desire for individualisation, that the punishment should fit the crime and the offender, and the desire to obviate unwarranted or unjustifiable disparity. This is a huge debate. What is justifiable differences and what is unjustifiable? The impact of sentencing decisions on victims. Public confidence. Again and again we come back. One of the important roles for the council is not just guidelines, it's in the development of public confidence in a sentencing system. Again, I stress that is one of the bedrock issues for any country. The costs of sentences and the results of monitoring. So who have they got on? This is a judge or judicial dominated council. And so eight judges or judicial members, 6 non-judicial. So that's one model that you might want to follow. The Victorian Council, and I'll talk more about Victoria because I know more about Victoria, this was our little mission statement. We had a planning retreat, which I hate. The very first year, our first CEO says, we must have a retreat, get together. Retreats, and we're going to come up with a mission statement. Hate mission statements. But nonetheless, despite my best judgment, just shows you can learn. We came up with this, which has now been copied around Australia as a summary of what we do. And it says we bridge the gap between the community, the courts and government by informing, advising and educating. And that notion of bridging the gap between different arms of government and the public, so between each other judiciary and government, government and the people, judiciary and the people, and so on. We are a linchpin, if you like, a hinge between various parts of the political, judicial community. And that, I think, really captures what a council can do, bridge the gap. It doesn't legislate. It has no power, but it can inform, advise and educate. We are a sentencing advisory council. So our statutory terms of reference in the Sentencing Act, Section 108, is to advise the Court of Appeal on guideline judgments. I'll come back to that in a moment. Provide statistical information, including information on current sentencing practices. That is, if you're going to have consistency, consistency against what? Do you know what the judges in one part of your country are doing compared to another? In one court compared to another? For one offence compared to another? Within offences, do you know what the range is? Do you know what the average is? Do you know what the standard deviation is? Do you know what the categories of offences within the one offence are? If you have that information, then it's terrific. But in the absence of a great statistical office, which most countries don't have, there is very little data about sentencing. So it's either anecdote, newspaper information, a book that somebody has in court, judge's own information, but there's not a lot of transparency in relation to sentencing information. Conduct research, gauge public opinion, consult broadly, and importantly, advise the Attorney General. The Victorian Council is lucky in the sense that we have two mandates. One, we are given the mandate to advise the Attorney, and seeing he pays the bills, we never say no, but we do negotiate with the government on the nature of the terms of reference and what we can and can't do. But we can also do things that we're interested in. We have an own motion power, which is great, because in the nearly 10 years we've been operating, we've never run out of ideas, believe me. Never run out of ideas about what to do about sentencing. But one of the important tasks is to be responsive to the needs of government, especially when there is a crisis, when there is newspaper headline, when there is something that happens. One of the important things is to allow the government, the Minister for Justice, to say, this is an important, emotive, difficult issue. It's called the mirror principle. Very important. The mirror principle, you heard this one? I will look into it. And what's important for a government is to say, I will hand this difficult problem, which I do not wish to advise now in the heat of the moment, and I will give it to the Council, and in 6 months' time, I will get an answer. And maybe the debate will have moved on, people will be more interested in cricket or football or rugby, whatever is the issue of the day, and you can then get an answer which is not forged in the heat of the moment. And I think that's an important role. So this is a little diagram that we publish every year in our annual report, and you can see this is how we bridge the gap: the community, the council, the courts, the government, information and education between the lot of them. So we see this as a really key role. We are a linchpin for a dialogue, a discussion between various parties. Who's on our council? We now have 15 members. We have a secretariat. It used to be about 18 people. We're down to about 10 now because government cutbacks, budgetary stringency. As I said, Tasmania has one. It varies. We have a budget of about $2 million. So if you're going to have a council, it can't run on a shoestring. It's got to be supported. So be prepared to invest in it. You're very lucky there. We have someone in the audience who used to work for our council. She's on leave, who's now spending 2 years in KL with her husband, who's got a job here, and she'll be happy to talk to you about what it's like to be on the Secretariat. I can certainly talk to you about the council. The members represent a wide range of perspectives, and when I say robust debate, when you have that range of people in the room, and we meet every last Thursday, so once a month for about 3 hours, these are not shrinking violets. The senior prosecutions, senior barristers, senior people, they're not shy to give us their views. And that's what you want: honest, decent, robust debate. And because they're not representatives, but they're in their own capacity, they can say, look, this is what the police department may think, this is my view on it. And that's great, because they're not binding and they're not parrots. They're not speaking for somebody else. So, Who's on our council? Senior member of an academic institution. By the way, this is in the legislation. The categories are in the legislation. That's something else that you might want to think about if you go down the pub. And that happens to be me, broad experience, defence, prosecution, victims. You can read that, but you've got the general idea of the categories. Okay, how do we interface with sentencing policy? And we're only talking about policy. We're never talking about anything to do with any individual case. And it's my policy, I'm the only spokesman for the council, there can only be one spokesperson, never comment on individual cases, because the press will come to you and say, wasn't that an outrageously low sentence in the case of X? And I say, I'm sorry, the council has no views. We do not interfere, not discuss individual cases. That's for the courts. We are policy driven. We are not a complaint body. And we made that clear from the first day, and we never get any. People don't ring up and say, Justice Smith has had, I want to complain. That's not our role, and they never do. Although, when we have cases where people are genuinely upset and hurt, we will try to assist them in advising them about the operation of the justice system, but not in relation to their case. That's not for us. We don't have any power to implement recommendations. We just give our views to the government, and it's up to them. So we have no power other than the power of persuasion. And we have the broad goal of increasing public awareness. And so really what's important is to improve the quality of debate about sentencing. So again, this morning I heard a discussion about capital punishment or about mandatory sentencing. They are the issues that you want ventilated in an empirical, scientific, dispassionate manner, getting a range of views. That's the kind of debate a sentencing council ought to take, have leadership of. The New South Wales Council, they do have sort of guidelines, which the High Court has now struck down, called standard non-parole periods, which are presumptive minimum sentences. Again, guideline judgments. They didn't produce some, the court did there, but again, the High Court in Markarian, in another case, knocked out guideline judgments for Victoria, Australia. I'll come back to that. Monitor sentencing trends, prepare research papers, educate the public. Tasmania, again, non-statutory, improve the quality of information, undertake research, inform the public. You can see, generally, you can get the thread of it, but none of these councils is solely concerned with guidelines. That's the point I want to make there. I've just seen recently that as a result of discussions in Ireland, there's a bill which is coming into Parliament in April, next month. Again, the same issues that you're facing. You are not alone in looking at these issues. To promote greater transparency and consistency in sentencing, whilst maintaining the independence of the judiciary. Interesting how we have to keep saying that these councils are not there to restrict the independence of the judiciary. Nobody's arguing that. What you want is clear, fair, consistent approach to sentencing, analysis and research, public confidence. I think you're getting the drift of what the international councils are about. Okay, let me briefly tell you about what we do in Victoria. Okay, guidelines. Although our legislation allows guidelines, and we have a process whereby the Court of Appeal can issue guidelines, it needs to call a bench of 5. It needs to then ask the Sentencing Advisory Council for its advice. It can then get that advice. It can then ask the DPP and legal aid to become opposing parties, if you like, to talk about the guidelines, and you can then issue a guideline or amend one. There's quite a detailed process set out. Interestingly, for Victoria, it is judicially created guidelines, unlike the UK or the US, where they will be guidelines that may come from Parliament or from Congress or from some other body. Ours is judicially determined. That's the theory. In the first 9 years, no president of the Court of Appeal has either been willing or able to get a bench of 5 to agree to ask for a guideline judgment, because there is not a belief that guideline judgments are appropriate for Australia. So the High Court is antipathetic to a guideline system. The system in Australia, which is ascendant, and I'll talk about it in a few moments, is an intuitive synthesis that the court takes into account all the factors relating to the offence, the offender, the victim, legislation, and then synthesises all of the factors to come up with an appropriate sentence. I happen to believe that that opens the way to too much unjustifiable disparity, but it is the dominant view in Australia. So I'm not going to hold that up as a model. I happen to believe that a moderate guideline system is possible without interfering in too much discretion in the name of consistency. But that is not what is happening in Australia. So in 9 years, we've never been requested to produce one guideline judgment. The Sentencing Act, that's what it says, have regard to the need to promote consistency of approach. Now, this is another interesting issue, consistency of approach, not consistency of outcome. So it's a process-driven guideline system, not an outcome. That is, unlike the Americans, the federal system, which has sentencing grids, numerical guidelines, it's a grid which says gravity of the offence on one dimension, prior convictions on another axis. You work out where this falls and you have that much discretion left. So it's very much a statistical system. The Supreme Court of the United States has knocked some of the strength out of that by saying that they're too prescriptive and unconstitutional. So they've gone back to the middle. So Australia lies at one end of the individualisation. The American federal system was at the other end. I think we're sort of moving closer together. What do we do? And when I've spoken in other jurisdictions where the focus has been on guidelines, they said, well, what the hell do you do? You've got $2 million, you've got all these staff, how do you fill in your time? Well, I'll show you how we fill in our time. In response to Attorney General's commissions to us, together with our own projects, I will just indicate to you that Victoria is not bereft of problems in its sentencing system. There are always issues that are of public interest and of legal interest. The law, it may surprise some people, is not perfect. I know that'll come as a shock to many lawyers, but it's not perfect and in constant need of a reform or review. So our very first reference came out of precisely what's driving your debate here, and perceived inadequate sentence for a rape. And rape is a highly important, highly emotive, very charged issue in any society. This young man got a suspended sentence, went on appeal, 2 judges upheld it, 1 was against. The attorney gave us a reference not on penalties for rape but on suspended sentences. That's taken us about 8 years, and the reforms are still working their way through our system. One of the things we do, by the way, is every year or so we go around to the heads of the jurisdictions. We have a magistrates court, a middle court, a Supreme Court, Court of Appeal, and we say, with our tongues in cheek, we're from the government, we're here to help you. We're not from the government really, but what are the problems that are confronting your court? Tell us what you haven't got the resources to do, we'll see if we can do it. So they thought the maximum penalties for repeat drink drivers was inadequate. We did a report on that. Parliament accepted it. They went up by 600%. Maximum penalties for preparatory offences. Police were not happy with what the courts were doing for offences like going equipped to steal, and, you know, not attempt, but even before attempt. We said it's not a sentencing problem, it's actually a substantive law problem about the law of attempt. We're not going to deal with it. Again, maximum penalties for negligently causing serious injury, breach of intervention orders. We did work on sentence indications, on provocation. Provocation was abolished in Victoria as a substantive defence. We don't have manslaughter on the grounds of provocation. It's now a sentencing factor for a charge of murder, and so we did a report on how would it now be reflected in sentencing rather than as a substantive defence, reducing murder to manslaughter. High risk sex offenders, done work on the prison population, on homicide sentencing, driving whilst disqualified, mandatory sentencing, statutory minimum sentences. We've looked at the parole system, a baseline sentencing scheme, which is sort of like a presumptive minimum terms. We've looked at sentencing severity for a range of offences. We've looked at current sentencing practices for these offences. We've looked at sentencing appeals in the Court of Appeal. Have looked at how they deal with them, what the outcomes are, how quick they are, what the grounds of appeal are, what's successful. We've looked at sentencing children and young people. We've asked, does imprisonment deter? We've said no. The government didn't like that. response, but we said, how much does incapacitation work? We said, a little bit, but not for the amount that you pay. People didn't like that as well. We've looked at sentencing for offences motivated by hatred or prejudice. All of these reports, by the way, are on the website. I'll show you that in a second. They're public. Okay. We're looking at fines now. We're looking at family violence. We're looking at sentencing Indigenous offenders. We're looking at re-offending following sentencing. We've just created, for the first time in Victoria, an offender database. That is, after 2 or 3 years of work, we're now able to identify individually every offender who goes through the court system. We've got corrections information, we've got court information. So we're able to know whether Mr. X or Ms. X, who was sentenced in 2004 or 2005, 2006, what happened to them? Did they come back before the courts for another offence and be resentenced? So we are now able, and our first paper on this is coming out in a few weeks' time, to ask whether is imprisonment more effective than fines or probation or bonds or diversion by looking at what happens to people. It is a stupendously important database to see, does sentencing work? Not is it just and appropriate, does it work? And this is the question a lot of people would like to know. So we're doing work on that. We've done a lot of work on public opinion, and we believe that public opinion is not what people read in the newspapers. I don't know whether you have talkback radio here, but it's highly influential in some cities of Australia. So part of our statutory function is to gauge public opinion, what we know, how we know it, and we've done some really important work about myths and misconceptions about public opinion, because what we believe is an informed public opinion, not an ignorant public opinion, as a foundation for public policy. So we've done quite a number of papers on this. Again, everything is on our website. What will predict confidence? What will predict punitiveness? What do people think about the purposes of sentencing? What do people believe about the alternatives to imprisonment? And those views are, of course, quite different from what you read in the newspapers. We do a lot of community engagement. So we talk to the profession, victims, offenders, judges, corrections, the general community. That's a very important part of our role, is community engagement. How do we do it? We have interviews, we have roundtables, we have focus groups, we invite submissions, we have opinion polls, we have public forums, we have focused forums. If you're going to be serious about it, you need the staff and you need the methodology, and you need to reflect it in your report. So this is very much about engaging the public. These are not hollow words. We actually go out and actively seek engagement, especially when we do our references. Just to show you how modern we are, just because I've got a grey beard doesn't mean that I'm not friendly with Generation Y or wherever we're up to these days. And in 2011, we established a Twitter account. I'm not a tweeter, but I'm told about these, and apparently, I found out a couple of days ago, we have 1,014 followers. We've published 1,047 tweets, and we're followed by lawyers and practitioners. And we also have a web page, which I'll show you in a second, and we've received 65,000 visits in the last financial year. So this is the way of engaging and informing. It's not just putting out a paper here or there, it's actively going out there and telling people and getting them. The other thing that we do, which I think we've pioneered, I'm sorry, you forgot to tell me on here. Something called You Be the Judge. I used to do this personally for many, many years, get groups of people together. I'd give them a vignette, a case study, and I say, you think sentencing is easy? You read the newspapers, you think you do better than the judge. Okay, you be the judge, and we go through a particular case, and then we ask people, and not surprisingly, the sentences range from a bond to life imprisonment. That's a bit of disparity because they can't say every case is different, because we say, no, you've all got the same case. Believe me, I've done it with judges, and we get a vast range, and they say every case is different. I said, no, it's the same case. It's you that's different. And then we work out the process that judges go through. So because I and the staff of the council could not go and talk to everybody in Victoria, we believed one of the best ways of getting people to understand what was happening was to get into the schools. As part of the education of high school students, they need to understand their democratic, their governance system, and their legal system. And there are many students who will study legal studies. I don't know what your high school curriculum is, but I'm sure there's something on civics, something a bit on law. What we've done is we have created these You Be the Judges for teachers to use in classes. We then train the trainers. I do a session with teachers once a year. We also go out, we provide them with resources, with CDs, with guidebooks, and this gets out now to thousands upon thousands of students as part of their high school education, so they can learn about the legal system. So as you can see, we are trying to get to the young people, see what they can understand. We did a, so we've done all that. We've done a booklet with judges to explain sentencing to the public. And what we have, and I can't show you right now, but I do encourage you to do it. I've run whole classes on this. If you go on our website, which I'll show you in a moment, we have an interactive video, You Be the Judge. And you can get on this and you can see that they're actors, but they're based on real cases. You can see the people, you can ask questions, and you can judge for yourself. And this has been downloaded thousands of times as well. So what else do? We do sentencing monitoring. So we, on our website, provide research into sentencing trends, and we use statistics for all sorts of reasons. So we inform the public, we inform our own research, and we provide great transparency for judges. We provide information about sentencing trends, about correctional populations. One of the innovations that we had, which has now really taken off, which has changed the discourse of sentencing in Victoria, go on to that, is the sentencing snapshots. Now these are 8 to 12 page summaries of sentencing. For the higher courts, we've done it for all of the major offences. We've now published 135 of them. They're very easy to read and understand. And what's happened is, although judges in Australia and in Victoria hate statistics, and they say every case is different, in order to be consistent, you've got to know consistent with what? Consistent with current sentencing practices. Our Act actually says a judge has to take into account current sentencing practices. So what do statistics mean? Well, even though the judges hated it, what's happened now is, as part of the dialogue, a member of the bar, that is defence or prosecution, now come in as a matter of course and say, look, on a submission, the average for this is, my case is pretty much like everybody else's. Somewhere between X and Y years might be appropriate. If you're going to give them 25 years, I should show you nobody's ever given 25 for this. And when it goes on appeal, the appeal court judges say, look, statistics don't determine our answer, but this is 25 years, and the highest it's ever been is 15 years, and there's no reason why this is different, and therefore it's manifestly excessive. So it's now been cited over 150 times by the Court of Appeal, so it's become part of the sentencing dialogue. Information. It doesn't infringe on the independence of the judiciary. All it does is provide them with information about other sentencing practices. Okay. So a court recently in Victoria said it's not inappropriate for the DPP to provide information to help the courts in sentencing. Our newest innovation, and again I invite you to look at this on our website, and I'm very, very proud of this, is something we call SACSTAT, which is an online tool which provides sentencing data for most offences in the Magistrates Court. 430 offences, 3 years of data. If you're going into the court, you can say, here's the information. The average here is 3 months imprisonment or a community order of probation. Magistrates usually know what the going rate is, but it may be different in every state, in every region, and it will inform them. All of this, by the way, every bit of information is public. There is not one secret database. Everyone, including the public, has access to this information. So, I just want to, if I can get to the website, if I can just throw to the, I know we have it. I just want, before I finish part one, we have it. Just go to the other. That's it. Okay, lovely. See, modern technology. Here we are, straight into the heart of Victoria. Modern technology will get you straight there. This is our website. As you can see, we're a finalist for the Media Awards for our You Be the Judge. That's a teacher's kit. You can see, if you go onto the publications, every publication that we've got there is alphabetically or by topic. We've got a bit about sentencing, and if you can you scroll down the page a bit? That's it. Fantastic. It's all there. It's all accessible. As I say, we get 65,000 hits a year. A lot of the research papers are used around Australia and around the world. The thing that we believe very strongly, and I'll finish on this note, is that our research is independent and our research is credible. And even if it's not picked up in Victoria, I know that in other parts of the country and around the world, people are reading it to help inform them about sentencing. One of the things I haven't shown you, when I went through all the projects, I do have another slide which I didn't have time to do, which is how many of our reports have been picked up and our recommendations turned into legislation. I think our strike rate, if I can use that, is about 70%. That is, we now have such credibility that even if they don't adopt everything, and they never will, that this is not just an empty gesture. That is, Parliament, the government, will listen to what we say, read our recommendations, and adopt them all or in part at some stage. I think that's a real triumph, and that's what you need to do. You need to have a credible council that will be respected by governments and the judiciary. We'll stop for a 5-minute break there, and then we'll go on to talk about consistency.
Distinguished guests, Professor, can we request for a 10 minutes break? Yes. We have now consistency in our breaks. Thank you, Professor. We will resume approximately 10 minutes from now. Thank you.
Consistency between the slide and the presentation, because the laptop and the presentation are not coordinated. So if I fall out, please signal me. This part of my presentation is based on a paper that will be published in a few weeks' time, I hope. It came out of a conference, international conference on sentencing. So just in case you feel you're alone with this problem, believe me, it's everywhere, certainly in the common law world, but in European jurisdictions as well. And I will leave a copy here with the Bar Council of the paper. And I have to acknowledge the work of one of my PhD students, Sarah Krasnostein, who is spending, just in case you think this is easy, spending 3 years trying to solve the problem of how do you produce consistency, how do you deal with unwarranted disparity, particularly in an individualistic framework as we have in Victoria or in Australia. As I've just said a few moments ago, the High Court, and again we had the quote from one of our most famous cases, Markarian, where the High Court essentially said that the process by which you go about sentencing is to concentrate on the individual cases and intuitively synthesise the outcome. So this paper is about, her thesis is about what are the mechanisms to bring about consistency, and you'll see from my presentation that guidelines are only one mechanism that you can use to produce consistency. And the challenge of her thesis is not simply to talk about the mechanisms, but in fact what's remarkable is, although there is a huge literature on the mechanisms, there's almost nothing that evaluates whether they work or not. Now, it's all very well, and I'll say it up front, to say, well, we're going to set up a council, or even without a council, we're going to introduce sentencing guidelines, and these will be there for the courts, and they will follow them as they see fit. there's almost no empirical work that's been done to show, do they actually reduce unwarranted disparity? That is, do any of these mechanisms actually work? Huge literature on, should we have narrative guidelines, should we have numerical guidelines, should we have statistical guidelines, should they, say, be made by councils, by courts, by governments, by commissions, whatever it is. Do we know whether they've made any difference? And there is not much evidence either way. And this is what her thesis is about. So, let me set the background there. And I think in any sentencing system in the common law world, and we draw on the same traditions, Malaysia, Australia, UK, Canada, New Zealand, United States, that there is a perennial and endemic tension between these two principles. Individualised justice, that is, the sentence has to be appropriate for the particular person in front of the court. There is no harder task than sentencing, no more important task in my view. In fact, if I had my way, even though I was Dean of a law school, I've never convinced anyone, I would make sentencing compulsory and criminal law optional. Why? Because 90% of our cases, there's a plea of guilty. The hard work is in sentencing. We teach them, I'm not saying, it's only a semi-joke, I'm not saying we shouldn't teach them the principles of substantive criminal law, but the reality is that with pleas of guilty, and again, I don't know what it's like in your country, we're dealing with people's liberty, with people's freedom, people's property, people's lives, and we don't train our judges and we don't train our students in sentencing, which is just as complex and just as difficult. And what happens in any broad system is this: how do we deal with the case in front of you? An individual human being who's not the same as any other human being. An individual person with their own background, own number of charges, the facts of the case. I understand they will never be identical. There will never be two identical cases. On the other hand, it doesn't say that cases can't be similar when you've done 1, 2, 3, 20,000 cases. There are patterns of individuals and patterns of cases. On the other hand, one of the fundamental notions of justice is that like cases should be treated alike. It's the rule of law. It's not the rule of man or woman. It's not the rule of the judge, whether the judge got out of bed feeling happy or sad or severe or lenient. It's the rule of law. And the rule of law says that like cases should be treated alike. So the question is, what do these mean in practice? Well, here's a little diagram that we've drawn up to try to summarise it. So on this side we have this individualistic paradigm in which discretion in the hands of the judges is paramount. Basically, other than the maximum penalty, other than something else that the Parliament may put in, that we say to the individual judge, you deal with the case in front of you, all of the circumstances, you've heard the witnesses, you've heard the offender, you've heard the plea and mitigation, you've heard the prosecution, got the victim impact statement, the pre-sentence report, whatever it is, you are the one who has all the information. Then you synthesise that information based on your knowledge, your wisdom, your experience, your judgment, and you will come up with the right answer. On the other hand, you've got the desire to say, well, while discretion is important, it's not the only issue that's at stake here. That treating offender A, who has committed these offences in these circumstances with these prior convictions, offender B has a right or expectation to be treated in a similar way if all of the relevant factors are similar. I'm never going to say the word identical, are similar. So it shouldn't depend on whether Judge X is the person hearing the case or Judge Y. Now we know that in reality that's what happens. We have judge shopping. I'd rather go before Judge Y because Judge Y is more lenient than Judge X. I know it's not in Malaysia perhaps, but We know that people judge shopping. We know you can't shop on the internet, by the way. You can't get a judge on the internet anymore. But with You Be the Judge, you can. The point is that a justice system should not depend upon which judge or court you're in front of. It should depend on the rule of law. How do we bring these together? And in the middle, it's that challenge of matching sufficient discretion to deal with real and justifiable and warranted differences between cases, and on the other, the rule of law. Like cases should be treated alike. So, the individualistic paradigm says discretion is central, and every judge I have ever met, and believe me, I have met a lot, and I've been involved in judicial training, and I know some of my friends are judges, some of my students are now judges, many of them are judges. The discretion, they want to retain the discretion because that's their job. And in Australia, the proposition that the High Court has put down, and the Court of Appeal in Victoria, is that there's no single correct sentence. You can't say X years or probation is the correct sentence for any particular case. Why? Because individuals can differ and no two cases are exactly the same. Okay, I understand that. But they do say that a certain level of, sorry, that should read inconsistency. Oh, sorry about that. A certain level of inconsistency is acceptable and inevitable. That is, that's the way the system is. We can't do anything about it. That's what comes from sentencing as a human process. Name of a famous book in 1971. Sentencing is a human process. We don't want to give it to a computer. We don't want to give it to a calculator, as is said in the United States. So the appropriate methodology, as I've said, is an instinctive or intuitive synthesis. The judge brings their experience to bear and the right sentence comes out. The comparativist paradigm is that consistency is a guiding value which is fundamental in any rational and fair system of criminal justice. Now, while people say that again and again, that consistency is important, and we've heard it today, and this is the challenge before you, the tension between those, well, yes, in the abstract, consistency is important, but in sentencing, individualism is more important. And that you can't use statistics and you can't use other cases, you can't use anything. Why? Because every case is different. When you're up there making a plea in mitigation, as you powerfully did a few moments ago, your case, that's what you're concerned with. You want to deal with this person, and that's what the judge deals with. So, every system is faced with this dilemma. You don't want to go too far the other way. That is, you don't want to have such consistency that all individual differences are obliterated. That's not consistency. That's just blind application of a particular rule or guideline or law. On the other hand, if we left it to every single judge, it would be unjust. It would be not consistent with something as fundamental as the rule of law. So, the question is, what do we mean by consistency? Now we start to unravel all of the problems. And generally we understand it means that a sentence, a similar sentence, should be imposed on a similar offender or offenders who commit similar offences in similar circumstances, and they should receive the same outcome. Now that's a nice broad statement. We can all probably agree on that. Similar offenders, prior record, mental condition, gravity of the offences, similar offences, whatever it is, same amount stolen, harm caused, and in similar circumstances. Was it a gang? Was it a ringleader? We know that there are hundreds of aggravating and mitigating factors. We know nothing is going to be exactly the same. We're talking about what are the features of similarity that we ought to be looking at. And there are two branches of thought about this. One is, in sentencing, we're looking at consistency of outcome or consistency of approach. Now, this is key in understanding the kinds of mechanisms that you want. In Australia, the courts will accept or understand consistency of approach. That is, there are a certain number of steps that a judge has to take to get to the ultimate result without precluding what the ultimate, or mandating what the ultimate result is. Now, what that means is that there's some degree of guidance about the process of thinking. Now, when I do the UB, the judge, members of the public say, oh, 15, 20, 5, 11, how did you get there? Or I didn't like what he looked like. Oh, I had ugly eyes. Or I believe needs deterrence. Oh, I believe it needs punishment. I felt sorry. What about the children? She was drunk. She was horrible. How did you get there? It's a gut feeling. We hope we get more out of our judiciary. Now, in Victoria and every state of Australia, we have sentencing legislation, I'll come back to that, which actually sets out a number of criteria in the legislation which sets out the factors that a court has to take into account in coming to a sentence. And I'll come back to that in a moment. So there is a legislative prescription already about relevant factors which you have to take into account. And on top of that, you've probably got appellate court guidelines as to what those factors should be. But what this says is, one of the ways to bring about consistency is to get consistency in the way that you think about the answer. Right? So if we all do step 1, step 2, step 3, you might get closer to consistency than if you start at Z and I start at A. Consistency of outcome is basically what the much maligned but very famous United States federal guideline system is. For those, are people aware at all of the US federal guideline system? In that case, that's good. Your life is much better for it. They went down the path of saying, look, we can quantify all of the aspects of sentencing. We're going to set up a commission which is made up of judges, legal experts and various others. And what we're going to do is we're going to say not only what the relevant factors are, and we believe that there should be very few, but we're going to ascribe a number to them. Now, if you can imagine a grid with lots and lots of bars, and as I said, down one axis, you have the offence. So let's just say it's robbery. So you might have robbery 1, robbery 2, robbery 3, robbery 4. Maybe over 20,000 ringgit, under 20,000, 5,000. Whatever the numbers are, it doesn't matter. Or you have rape, or you have burglary, or you name the offence. And on the other axis, you have prior convictions. None, 1, 2, 3, 4, 5, and a weight to their seriousness. All of these are given a weight, and the manual, I don't know because nobody's printed it out, but it's on the website. It will tell you how to calculate these things. It can tell you what you can and can't take into account, maybe plea of guilty, maybe something else, and then it'll come up with an answer. Right? So here we are. Let's say middle level robbery. I'm just making up these numbers. 10,000 ringgit. 3 prior convictions for relevant offences. So you go down there, across there, and it will say between 110 and 115 or 120 months. Or in less serious cases, it will say incarceration, and this is what the sentence will be, or non-incarceration, this is what probation or something else will be. So it's not all about jails, but it leaves the judge about that much discretion. So that's consistency of outcome. You've got to fall within there unless you've got very good reason. And the Supreme Court said the restrictions were too great and unconstitutional because it wasn't done by a jury in terms of the finding of the facts of the case. So that's the approach that nobody wants anywhere, and that really does restrict discretion. A lot of US judges hated it and they bridled against it, but they learned to do it. So in terms of, again, consistency, what are we talking about? Well, if you're talking about co-offenders, there are all sorts of different aspects of consistency. Again, this is a whole chapter of my PhD students' thesis. So it could be the same judge dealing with co-offenders who are similar in different ways. So, I don't know how many appeals you take, but how come he got that and I got that, when we did the same thing? So the judge may make an error in comparing the cases. So that's one form of inconsistency. The second form is similar crime, but Judge A deals with it in that way and Judge B deals with it in a completely different way because they have different views about sentencing, different views about the world. Another form of disparities, adults and youths. You've got an 18-year-old or a 19-year-old with a 16-year-old. I don't know what your age limits are for your youth justice, but how come I get 3 years jail and he gets probation and we're only that far apart in age, that kind of disparity. You've got unrelated offenders, that is not co-offenders, but people who just commit similar crimes. How come they're dealt with differently? With the co-offenders, by the way, you can sometimes have the case that one co-offender will be dealt with in one court and another by another, simply because the judge has gone on leave or there are different situations. The other aspect of disparity, which is in the United States, disparity means being different from a norm or a guideline. When you get a guideline system which is very rigid, then the appeals are not so much that A got one sentence and B got another when they were similar. But in the United States, when you've got a rigid guideline system, the appeals will be on the basis, well, the guideline says 110 months, and I got 150 months. So disparity is disparity from a predetermined norm. That's a completely different meaning of disparity. So once you set a rigid guideline system, your jurisprudence changes quite dramatically. I don't know what your jurisprudence here is in terms of sentencing, but if it's anything like Australia, your appellate courts will be saying there will be an error of law, that is incorrect application of law, misapplication of facts, too much weight given to one fact or another, or, most popularly, the sentence was manifestly excessive in the circumstances, or manifestly inadequate if it's a prosecution appeal. That's the kind of jurisprudence which we've developed, but in fact, in the US, which didn't have a common law sentencing jurisprudence where discretion was that wide, now the appellate jurisprudence is, did you unwarrantedly depart from the guideline? And why? Can you see that's a different question? You don't say too much or too little, it's why did you depart? And you've got to come up with reasons for that. Now, the key issue, and there's no way of solving this, but the key issue in any sentencing debate is what is unjustifiable and what is justifiable. Well, justifiable or warranted discretion is if you produce different sentences on the basis of different legally relevant factors. So if offender A has pleaded guilty, shown remorse, and offender B in the same case, right? Just say all the facts of the case are the same except for that. And offender B is unremorseful and has gone to trial and wasted or spent 3 months in trial. Most systems will provide a discount for the plea of guilty. Now, you can say if offender A who's pleaded guilty and shown remorse gets X months and the other one gets X plus 10 months or years, whatever it is, that's a warranted disparity. You've got a reason. Or offender A suffering from a mental disorder or intellectual disability, offender B is not, and so on and so on. If it's the amount that's stolen, if it's the fear that's caused, if it's the harm to the victim, all of those, we can always say it's important for any system to recognise those differences because they are the ones that we either want to promote, that is, people pleading guilty, or the ones that we recognise that make people less responsible, like a mental illness, like intellectual disability. It's the unjustifiable or unwarranted problems that we're looking at, where you treat like cases differently. The other interesting thing that you have to be careful with guidelines, and especially the American federal numerical system, is there's a different form of unjustifiable consistency, and that is treating unlike cases alike. So if you set up a system of guidelines that is very rigid, then it's just as bad to treat different cases the same as to treat the same cases differently. So in our Australian system, our problem is unjustifiable disparity. The American guideline system is unjustifiable parity. They're both sins, in my view. Can you see that danger there? That a guideline system does not recognise, if it's done badly, does not recognise individual differences. So you've gone too far the other way. In many of the cases, what is it that causes the major differences? Well, one clearly is personal sentence factors. That is, the difference does not lie in the cases, it lies in the judges. And we all know all judges are different. Or as they say in an aeroplane, please concentrate. Each aeroplane is subtly different. Well, same with judges. Each judge is subtly different. And what we have is that judges will differ in their views of what an appropriate sentence is, the gravity of the offence, the appropriate just deserts, whether deterrence or rehabilitation is important. I believe that that should be minimised, that it ought not to depend on who you're in front of. Most of the United States problems have arisen, and why they've gone to a stronger guideline system is that they found in many, many studies that the difference is the nature of the offender. So many studies have found race is an important factor in disparity, so that blacks, Hispanics, other minority groups will be treated differently. And when you take out all of the other factors, statistically, you can only come back to race or ethnicity or gender. So what you want in any system is that these factors, which should not be in any system unless you've got a very good reason, those factors need to be accounted for so that prejudice does not come into the system. Now, interestingly, in Australia, and I come back because we're at the extreme end of the discretion spectrum, the contention that unjustifiable disparity is a problem, first of all, is not accepted widely. That is, every case is different. Don't tell us you can find similarities. I just don't accept that. If you've got 5,000 burglaries, in the human, this is what we call social science. You can find patterns of behaviour, patterns of offending, patterns of people. We are different, but we're not that different. You know, after you've done a couple of thousand, you can say there's this group and there's this group. And secondly, what's very strong is they believe that the cure is worse than the disease. The cure is worse than the disease. Yes, it might be inconsistent. Yes, we may have problems. Yes, we've got harsh judges and that. But what you're trying to do to fix it will make the system worse. Look at America. That's what they always say. Look at America, and especially the federal system. There are 23 other guideline systems in America, but the federal one is the one that's best known. So, how do we find, if you're going to prove, if you want to make your argument in Malaysia that there is unjustifiable disparity, tell me how you're going to prove it. Is it anecdote? Is it stories? Is it newspapers? Actually proving it is quite difficult. One, you've got to decide what are relevant and irrelevant factors. Secondly, how do you do it? Well, you can do it through simulation exercise. I've done dozens of these. I get the judges round in the judicial training courses, and we give them the case, and Judge A will give 1 year and Judge B 15 years. And we talk about, well, is this justifiable? Well, they said, yeah, I mean, we're all different. I said, well, if you're blogs and you get 1 from him and 15 from her, is that justice? Well, maybe not, but it's better than the alternative. I'm not sure. We can use statistics. In some countries, they actually measure what judges do and find out that this judge, or, and it's sometimes the case, this group of judges in this region sentence more severely or less severely than others. Well, that's regional justice. That's wrong as well. There's a New Zealand study coming out, which I've refereed for a journal, which has actually statistically shown that in areas of New Zealand, it's not the cases, they've done all the statistical controls, but some regions are different from other regions. And again, should justice depend on whether you're heard in Region A or Region B? We can randomly assign cases and just see what judges do. You can analyse factors. Anyway, the problem is if you're going to change your legal system on the basis of allegations of unwarranted disparity, then there's an onus upon you to prove it. How do you know it's happening? How wide is it? How bad is it? In relation to what? So, I now get to the crux of the presentation. Well, let's assume, that's what economists say, right? Let's assume that there's unjustifiable disparity to some degree, and now you want to redress it. So you want to maintain justifiable disparity, that is, legally relevant factors, get rid of unjustifiable disparity. And I know that this is the focus of your discussions, and I hope this morning I've given you a broader picture both of what what sentencing councils can do and what guidelines can do. Now, guideline judgments were developed in the UK in the 1970s. They were first judicially developed by the Court of Appeal. You probably picked up a few of those in your own country. What happened then is they evolved in the UK to become as part of the work of the sentencing advisory panels. They developed them. They were usually partly numerical, partly narrative, some of them based on extensive research. And now we have a Guidelines Council whose job it is to develop those in the UK. I think they then go to Parliament for approval, but the Court of Appeal still has the power to make its own guideline judgments. I think the Guidelines Council can recommend to the Court of Appeal what they are. They don't have to accept them. In Australia, many jurisdictions actually have legislation which permit it, and although 7 were handed down in New South Wales by the Court of Appeal under Justice James Spiegelman, the High Court, in a case called Wong, and then in a case called Macarian, said they are inimical to the instinctive synthesis, that guidelines were a job for the Parliament, not for courts, and this is an interesting constitutional issue about the separation of powers. What is the role of a court and what is the role of Parliament? It said that the role of a court is to decide individual cases, not to lay down prospectively what the law should be. And so part of the view was that guidelines can be intrusive on the legislative function. There was also a constitutional question, and again, I don't have any knowledge of Malaysian constitutional law, but in our system the argument was that a court had to deal with a matter in dispute. It didn't have a power to issue advisory judgments, and so it had to be a live issue, and a guideline judgment, being prospective, was not dealing with the facts of the individual case. Now, our legislation in Victoria has dealt with that, but the High Court says that's unconstitutional. And the fourth and most important issue here is that judges don't like to discuss things in the abstract. Our job, and it may be different here, our job is to decide this issue between these parties. Sometimes you'll get a broad statement, Donoghue and Stevenson, or some principle that's set out that will provide some guidance. But courts of appeal are reluctant to lay down prospectively broad views about the law. And so there's an antipathy for a court to say, in future, a serious rape will get X, a medium rape will get Y, and a not so serious rape will get Z. They'll say, we will decide this case, it was too high or too low, but they really do not like setting out things in the abstract. That's what councils can do. It still has to be adopted. Okay. The second mechanism, and again, I plead ignorance about the system here, but it's very important in Australia and in the UK, is appellate review. That most of your guidance will come from the Court of Appeal. So cases go up to your very highest court, and they will decide whether there's been an error. But the question is whether the court will then say, in future, this amount of weight should be given to a guilty plea, this amount should be given to remorse, the relevance of mental disorder is here, or in future these offences should get X or Y. Our courts really focus on error, but not guidance. And they have two kinds of error. Specific error, that is, the judge has made a mistake of law, or non-specific. We're not sure whether there's a mistake, but we think there's one there. But a lot of the work is done when they say just too high or too low. And so the guidance is I call this, and I'm sorry, I've said it in Australia to judges, I call this pin the tail on the donkey jurisprudence. Do you know this game? You've got your eyes and, you know, too high, too low, too high, low, just right. And so in the next case, I'm sorry if I'm offending anyone, but in the next case, you go up and you say, but this was too high. No, that was a different case. This case is different. But I think judges should get some guidance. I think especially new judges who haven't practiced in criminal need to know what ranges are appropriate. And so the way that judges do it in Australia is in each individual case, and there are hundreds, a tariff emerges from the too high, too low system. And this debate between individualism and comparativism is at the core of this. Judges don't want to be comparativists. The next mechanism, and I'm going through each of these, by the way, is a chapter in Sarah's thesis, is, okay, maybe one of the ways that we can promote consistency is to advise judges or give judges and the profession information about what other judges are doing. So if you're going up to a court, or if you're going to a court of appeal, and you say that this was manifestly excessive, I don't know what the language is here, or manifestly inadequate, my response is, compared to what? That is there a range of sentences? Now, the courts in Australia say, no, it's compared to this case, taking all the factors into account in relation, is it too high or too low? I believe, and Sarah and I have just written an article which says, no, compared to what means compared to current sentencing practices. So if everybody is giving 5 and you're given 1, if everybody is giving 5 and you're giving 20, then I believe that is a ground of appeal, because it is not consistent, it is not treating like cases alike. And if they are alike, then I believe that's a proper ground of appeal. So there's a lot of debate about statistics, their validity, their usefulness. Judges don't like them, but with our sentencing snapshots, we have shown that they can start to guide judicial practice, because in our legislation, it says current sentencing practices are a factor to be taken into account. Not the controlling factor, not the guiding factor, not the only factor, but looking at what other judges do is a way of promoting consistency. But for that, you need sentencing statistics. You need independent, verifiable and public data. Some states like New South Wales have a sentencing information system. We have snapshots, we have the information on the web, so that's part of the role of a sentencing counsel. Let me say that I don't think information itself is sufficient, but it's one of the steps. What else can you do? You can have judicial training. Australia has a number of judicial colleges. Victoria has one. Nationally we have one. New South Wales has one. And so new judges can participate. In fact, they're required in Australia to attend a week-long judicial education course where they will be taught about a whole range of things about being a judge. I do a session with a practicing judge on sentencing. We do simulation exercises. It's not going to teach them, but what's useful is getting together and talking about the job of judging. And if you've been sitting in tax law or family law or some other law, and all of a sudden you're put into a trial, what do you know about the criminal law? What do you know about sentencing? So information and education is important. We have a lot of resources to help judges. So the Judicial College of Victoria, and again, it's on their website, has a sentencing manual which summarises the law of sentencing. It's thousands of pages. A judge can go to that at any time. There are textbooks, there are bench books. So helping judges know about sentencing is important. One of the worst ways of promoting consistency, and because I believe this brings about unjustifiable parity, and it was mentioned again this morning, is presumptive and mandatory sentencing. Sometimes people say, well, the judges are all over the place, the judges are too lenient, the judges are disparate, we're going to introduce mandatory sentencing, or presumptive sentences, or presumptive minimum sentences. Well, of course, the danger with that is it looks consistent. That is, everyone who commits this crime gets the mandatory sentence of 5 years, or the mandatory minimum of whatever it is. But the problem is you're treating unlike cases alike. And I've just said, that's as bad as treating like cases differently. So I believe that takes away too much power from the courts, invests too much in the Parliament, and we've written some papers there on the problems, the advantages and disadvantages of mandatory sentencing, but it's something that politicians love a lot in an election campaign. We're going to get tough, we're going to introduce mandatory sentencing, and this will solve the problem. Well, you then find out, well, how about this case here? It's a terrible case. You know, the person had lots of mitigating factors. Sorry. And then the judges, like in the United States, says, you've taken away our power to distinguish between cases. I agree. Another way of doing it, and again, when I asked for information, I was very grateful for some people providing me information about your sentencing system. I wanted to do some homework, like a good academic. I found that there's not really one sentencing piece of legislation. I was involved in this in the mid-1980s. Every Australian jurisdiction now has, and I just want to briefly, if I can get the attention, I just want to show you, not this one, can I have the other one, That's it. Yeah, it's fantastic, isn't it? It's terrific. If we can go up. Right, this is the Sentencing Act, 1991, amended about 100 times since then, but I was involved in writing this, and what this does, you're probably in the situation we were in the mid-1980s, that you had provisions all over the place. It's in your Procedure Act, it might be in other pieces of legislation. So we brought together and rethought. We didn't codify the law, but we certainly made it orderly. And you'll see, if you can just move down a little bit, so if you go, the purposes, governing principles, the guidelines, factors to be considered in determining an offender's character, the discount for a guilty plea, then we have guideline judgments, and then if you scroll down just slowly, you'll see, just keep going, you'll see definitions of sentences, whether they should be conviction or non-conviction. Then we have provisions for pre-sentence reports, drug and alcohol reports, keep going, victim impact statements, and then each of the sentences, what the rules are in relation to the imposition. So we have imprisonment and how that works, indefinite sentences, how that works, drug courts, how they work, youth justice orders, community correction orders and their conditions, fines and how they work, keep going, more about fines, and then then bonds, dismissals, discharges and adjournments, how to deal with intellectually disabled offenders, deferral of sentences, contravention of sentences, special superannuation confiscation orders, then restitution, compensation, keep going, forfeiture and disqualification, mentally ill offenders, and then how you make a sentence, explanation of orders, how you pass a sentence, how you correct a sentence. What I want to say there, if we go back to the slides, please. So every state now has a comprehensive, consolidated set of provisions from which courts can work. And I think that assists in public understanding of sentencing, assists the legal profession, assists the courts. Okay. So now we get to sentencing councils. Sentencing councils will not in and of themselves bring about consistency in sentencing. They can provide information for sentences, they can provide an evidence rate for decisions, and in many jurisdictions they will work on sentencing guidelines for the courts or for Parliament. So it's indirect. A council in and of itself will not produce or not reduce unjustifiable disparity. It is one of the cogs in the wheels to bring it about. Finally, almost finally, how do you know whether you've been successful? And as I've said, you may aim for consistency in sentencing, and as the title of our article said, how do you know when you've got there? What studies have you done? How do you know whether the courts are more or less consistent, or if there's more or less unjustifiable disparity? It's not just enough to say, this is what we're going to do. Does it make a difference? And there are a lot of problems in doing that. And again, the problem is determining what is unwarranted discretion. As I've said, if you bring in guidelines which are very, very prescriptive, then disparity is Has the judge departed from the guideline? Not has justice been served, and we are very critical of the American guide. The appellate jurisdiction is, have you departed and why? Our question is, have you imposed an appropriate sentence for this person and why? They're two different questions. And the danger is that you end up asking the question, why did the judge move away from the guideline? Because the guideline will assume that the guideline is the correct answer, and I don't always believe that's true. There is evidence, however, and because I am a believer in moderate guidelines, that in New South Wales, when they introduced guidelines from the Court of Appeal, 7 offences, it showed that the range of sentences narrowed, that the level of sentences came closer to what the Court of Appeal wanted, and that the disparity levels diminished a little. Not completely, but a little. So I do believe that guidelines are an important way of bringing about a reduction in unwarranted consistency, but as you've heard this morning, they're not the only way. I think that counsel is an important and useful way of working on them. So, in conclusion, there is no correct answer to the challenge of balancing individualism and consistency. There is no correct answer as to what is justifiable and not. But if you do believe, as I've heard this morning, that you are passionate about the rule of law and bringing about justifiable consistency, then you need, in your future work, if this dialogue is successful, to work out what is appropriate for your country. What of these many methods are you going to adopt? How are you going to adopt them? And then ultimately the challenge is, how are you going to know whether they're going to work or not? And I believe a sentencing council would be an appropriate body to also do the evaluative work on the operation of these systems. I think that's been more than enough for you this morning to absorb. I've got a copy of the paper which I'll leave with the Bar Council that's coming out, which sets this out in detail. I do invite you to go wandering around our website, our Victorian website. The Tasmanian one, unfortunately, is a tiny one, because our one worker has to be researcher, administrative secretary, web page manager and everything, but the Victorian one is much more mature. I think we've got probably one of the broadest websites in the world. I do invite you to look at that, and this afternoon, as well as over lunch, I'm happy to answer as many questions as you've got. Thank you.
Thank you, Professor Eric Faber, for your graciously attending this dialogue and sharing your views and thoughts with us. I would now like to invite the President, Mr. Lim Chi Wee, to present a souvenir to Professor Eric as a token of appreciation. Distinguished guests, the itinerary for next event will be, we'll break for lunch from 12:30 to 2 p.m. And then thereafter, we will have 2 other speakers, Court of Appeal Judge Yang Arif Dato' Azhar Muhammad and also Dato' Sitambaram. That will start from 2 o'clock to 2:45, and then 2:45 to 3:30 p.m. And finally at 3:30 to 5 will be the Q&A dialogue session. And just to inform those guests who like to do their prayers, there's a surah on the mezzanine floor, a floor below this, if you need to do your prayers. Thank you very much. I hope many of you enjoyed your lunch. Professor Ari, I hope it wasn't too spicy. Ladies and gentlemen, may I now introduce the second speaker for today. Court of Appeal Judge Yang Arif, Dato Azhar Muhammad. Prior to him coming on the stage, a brief biodata background on Yang Arif. His Lordship started in the Judicial Legal Services in 1980 as a Senior Assistant Registrar, thereafter as a Magistrate and Sessions Court Judge. His Lordship then also was attached to the AG's Chambers as the Head of Prosecution and Head of Civil Division. His Lordship was elevated to the bench in 2004 and thereafter appointed as a Judge of the Court of Appeal in 2006. May I now have the pleasure to invite Yang Arif Dato Azhar bin Muhammad on stage.
Thank you, Mr. Ahmad. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good afternoon to all of you. First of all, I wish to thank the Malaysian Bar Council for inviting the Malaysian judiciary to participate in this very important event. Today's discussions concerns the proposal to establish an independent and advisory council referred to as a sentencing council, among others, to promote greater consistency in sentencing. I believe that any proposal to set up a council of this nature in our jurisdiction must be viewed and examined in the context of how our own criminal justice system presently works. In my presentation today, I will therefore try to explain a little bit about our present system of sentencing the offender and the legal principles involved in the sentencing process. This is about how judges and magistrates exercise their discretion in passing sentence. I will also touch on the difficulties and the challenges faced by us judges and magistrates in the sentencing process. Then I will give my views regarding the proposal to set up a sentencing council in our jurisdiction. But a caveat. What I will say are my personal views and do not necessarily in any way reflects the views of the Malaysian judiciary, especially when I give a bit of my views on the sentencing council. Now, to put the matter in its proper perspective, let me start by saying a few words about our criminal justice system. The aim of our criminal justice system is to maintain law and order and to sustain the rule of law, as well as to protect the public from serious, dangerous, and persistent criminals which cause concerns to us. The criminal justice system seeks to prevent crime and punish criminals. This means preventing the criminal from committing more offense, more crime, and putting others off from committing similar offense. You will all be too familiar with the notion that a strong and effective criminal justice system is important to make life more difficult for criminals, and that criminals are properly punished for the crime they committed. However, in pursuit of this aim, it must not be done at the exclusion of individual rights as guaranteed by our federal constitution. For instance, no person shall be deprived of his life or personal liberty save in accordance with law, and that all persons are equal before the law and are entitled to the equal protection of the law. Yes, judges and magistrates are given immense power over the life and personal liberty of individuals. They are given considerable discretion in the sentencing matters. And the proper and correct exercise of those discretionary power is a matter of concern for the offenders, the victims, the enforcement agencies, the public prosecutor, civil societies group, and I'm told some of them are here, and the public large. And in the context of today's discussion, no matter how appalling or shocking a crime a person has committed, our Criminal Procedure Code has outlined that the court shall pass sentence according to law. Passing a sentence according to law means that the sentence imposed must not only within the ambit of the punishable section, but it must also be assessed and passed according to the established legal principles. And according to the legal principles, in deciding the appropriate sentence, our court, in our jurisdiction, must first and foremost consider the public interest element. And the sentence imposed must strike the right balance between the public interest and the interest of the offender. And in striking this balance, certain objectives of such sentence must be considered. First, by punishing the offender, the aim is to reflect the society's disapproval or even a revulsion of the offense committed. And secondly, public interest is best served by deterring not only the offender from committing crime again, but also to deter others who may be similarly tempted or like-minded to do so. Now, public interest also is best served by inducing the offender to turn the criminal ways to honest living, or induce him to turn from a criminal to honest life. And in certain circumstances, treating the offender leniently and thus giving him a chance, that means to turn over a new leaf, is certainly not against, but actually very much in the interest of the public. Now, and as in other jurisdictions, except in certain cases, our penal legislation do not fix the sentence for a particular crime. A maximum sentence, and in some instances, a minimum sentence is prescribed for the offense, and the court is left to decide the appropriate sentence within the minimum or the maximum sentence for each offender. Criminal penalties are very broadly defined and have different level of seriousness. In other words, we judges and magistrates apply the law within the legal framework set by Parliament. And this actually has resulted in the competing values in which the competing sides are the interests of the public and against those of the individual offender. When imposing sentences, judges and magistrates are always confronted with the apparent conflict between the two fundamental interests. It is all a question of balancing the needs and rights of the community with that of the offender. The balance must be struck between the public interest and the interests of the offender. And herein lies the problem of balancing the competing interests in the sentencing process. Sentencing, indeed, is one of the most difficult, challenging and complicated part of the work of a judge, as well stated by His Lordship Justice Rauf, President of the Court of Appeal, in the famous case of Noor Afizal bin Azizan against public prosecutor, which became a case of interest sometime last year. And to which I might add my own experience. You know, I can still remember as a young magistrate 30 years ago how difficult it was to pass sentence involving a young offender who was convicted for theft of a pair of jeans from a supermarket. And even now, as a judge of the Court of Appeal, I find this aspect of my judicial work is so challenging. And I still remember 5 days ago, sitting in a panel of 3 judges, we have to decide to pass an appropriate sentence in a case involving a juvenile, a young offender, and a victim who committed a statutory rape. We all know that in passing sentence, judges and magistrates must take into account all the mitigating factors: the plea of guilt, the age of the offender, whether he has a previous conviction, the conduct of the offender after the commission of the offense, the effect of the conviction of the sentence, the prevalence of the offense, and so on and so on. But it is easily said than done. In reality, and as a matter of fact, it may be very, very different when you see the offender in front of you. You have this tragic figure in the dock, whose future you are about to decide whether he or she will be incarcerated with fine or fine over. Sentencing process, in fact, can be clouded by emotive considerations or surprising details in the facts of the case. And because of the obvious grave consequences, we judges and magistrates sometimes generally have very cautious, we very cautious and careful when we sentence an offender. And this position actually is stated by Hashim Yobsani, his lordship then was in a case called Lu Chun Fat against PP. And his lordship described it in these words, if I may quote him. He said that judges and magistrates are often inclined, quite naturally, to be over-sympathetic to the accused. This is a normal psychological reaction to a situation in which the lonely accused is being faced with an array of witnesses with authority. The mitigation submitted by a convicted person will also normally bring up problems of family hardship and the other usual problems of living. In such a situation, the court might perhaps find it difficult to decide as to what sentences should be imposed so that the convicted person may not be further burdened with additional hardship, unquote. Now, the learned judge, of course, then in his latter part of his judgment, quickly reminded us, judges and magistrates, that this is a wrong approach. His lordship reminded us that we must consider the interests of justice as well as the interests of the offender, in that it is too often nowadays thought, or seems to be thought, that the interest of justice means only the interest of the offender. And you all may recall the wise word of Raja Azlan, FJ, as His Highness then was, in the case of Hashim bin Saud against and another, where his lordship says that, but justice does not mean only to the accused, it also means the interest of the state, and not enough is paid to the interest of the state. In my view, those words coming from a very learned judge almost 36 years ago should be accepted as expressing a cardinal principle. So sentencing by judges and magistrates plays a very important and demanding role in our society. It is important for society and for individual victims that those who break the law are suitably punished. It is the duty of the court to respond effectively to crime. If punishment is not imposed, or if the punishment is generally perceived as too lenient, the victim will be left with a sense of injustice and grievance. And public confidence in the criminal justice system will be eroded. Hence, it is important to ensure that the courts across the country are consistent in their approach to sentencing, unless it is contrary to the interest of justice to be so. Which brings me to the criticism, some criticism level against judges and magistrates, in that at times we are said to be soft on sentencing, and that we have failed to treat certain crimes with severity that they deserved. Sometimes the public think that the sentences we impose are too lenient and that the courts are out of touch. But when we express our dissatisfaction about disproportionate sentence imposed by the court, it is important to bear in mind that sentencing in a criminal case must bear to the particular circumstances of the case as well as to the particular circumstances of the offense. My view is that each case depends on its own peculiar fact. No two cases I haven't come across in my 30 years experience in the administration of criminal justice where the two cases bear the same facts and circumstances. In this way, a sentence meted out in one case must, in my view, necessarily be different from the other. Every crime and every criminal, in my view, is in fact unique. As stated by Wan Yahya J, as his lordship then was in a case called Safyan bin Abdullah and another, quote, sentencing offenders is a complex discerning process which depends not on the use of common mathematical yardstick, but on various consideration of facts and circumstances relating to the offense, the offender, and the public interest. In my view, what has happened is that more often than not, criticism by the public on sentencing given by the court is made without the advantage of having read the judgment of the court and without the benefit of knowing the full facts and the circumstances prevailing of the particular facts. The facts, to my mind, are necessary to understand why offenders get the punishment they do. Moreover, in my view, generally, our public does not know the way the sentencing process works and undertaken by we, judges and the magistrates. The other common criticism is the perceived issue of disparity in sentencing, where sometimes it is said that the fact that offenders who have committed similar offences receive dissimilar sentences. I understand the concern that lack of uniformity in sentencing, if unexplained, has the risk of undermining public confidence in the administration of criminal justice. In my view, to a large extent, the cause of disparity lies in the intrinsic nature of our work, of the sentencing method and the procedure itself. If the punishment for an offence is fixed by the statute, then there is no room for the exercise of judicial discretion, and lack of uniformity and sentencing would never arise. As I have mentioned a moment ago, as in other jurisdictions, we have here Parliament that make legislations stipulating punishment for specific offences and the maximum limit, and in some instances, as I've said, the minimum limit which can be imposed by the courts. The court is left to decide the appropriate sentence within the maximum or the maximum range for each offender, taking into account the particular circumstances of the case. Despite the inherent weakness and the imperfection of the current sentencing policy and process, it is my view that generally, it has worked well and meets the end of justice in each case. There are already sentencing guidelines laid down by the courts. Our bench book has a chapter on principle of sentencing. We set out the general principle on sentencing. And I think in sometime August last year, the practice direction number 2 of 2012 was issued by the Chief Registrar of the Federal Court, which sets out sentencing guidelines for particular serious offences. And judges also sometimes refer to case law authorities to examine how sentences have been reached for similar cases in the past. But I agree that those guidelines are not sufficient. Under our present system, if there is any issue relating to proportionality or unwarranted disparity of sentence, there is the appeal or the revision process to identify and rectify it. And as I stated over the lunch to the professor here, that we also have the revisory power of the High Court to revise a case in a particular case, even when there is no appeal process. And of course, the offender or the public prosecutor has the power to appeal, often successfully, against sentences they consider to be too excessive or lenient. But of course, there are limitations. There are limitations in the appeal process. It's not every day that cases goes to the appeal court, and also even if cases go to the appeal court, I think each one of you know the principle that the appellate judge is very, very slow in interfering with the decision of the trial judge on the issue of sentence. So you can see that there are some mechanisms in place in our system to ensure that appropriate sentence appropriate punishment are meted out in individual cases. But having said that, in my view, there is much room for improvement under the present system, practice and policy in order to enhance our administration of criminal justice. And this brings me to the idea to set up a sentencing council in our criminal justice system. As I understand it, the proposed council comprised of judges and other experts in different aspects of criminal justice from various backgrounds. The council, among others, would then develop and prepare separate guidelines for the judges, but the final decision would still be in the judge's hand. In my view, there are at least 5 benefits to be gained by our judiciary for this proposed sentencing council and their role in preparing guidelines for the judges. First, the first benefit that I can see is that the sentencing council produces guidelines for the courts. Sentencing council will give guidelines to assist the court to decide the appropriate and type and length of the sentence. The sentencing guidelines for individual crimes set out a range of punishment, reflecting different levels of seriousness, and within each range, and a proposed starting point for the punishment for the courts to consider. This, I think, is very, very useful for the magistrates, for the young and inexperienced magistrates. The guidelines will provide guidance on factors the court should take into account that may affect the sentence given. This will ensure that all relevant factors are taken into account. Secondly, the sentencing guidelines may reflect public opinion on the appropriate sentence to be imposed on offenders for particular crime, as draft sentencing guidelines are circulated and form as a basis for consultation. There is opportunity for public to give feedback and response before a definitive guideline is finalized. In this way, in my view, the proposed sentence contained in the guideline can be said as a reflection of public opinion. This will improve public confidence in sentencing imposed by the courts. Number 3, of course, sentencing guidelines provide some elements of consistency. The guideline sets the parameters and provide a framework within which we judges and magistrates can approach sentencing in a more consistent manner. The sentencing guideline will set out a standard and consistent as well as transparency approach for all courts to follow. This, of course, will promote consistency in sentencing and minimize the disparity in sentencing. Number 4, sentencing guidelines also allow indirectly for public participation in the sentencing of offender. The council, as I mentioned, may undertake research and then obtain feedback from the public and follow a step-by-step consultation process before finalizing the guidelines. This would invariably involve public participation in the sentencing process. And the last, and but not least, the 5th benefit that I can see, that sentencing guidelines increase public awareness and understanding of sentencing. Under the present system, the public are not entirely clear about the way sentencing process is undertaken by the courts. There are, in my view, many mistaken beliefs about sentencing. Public is not clear as to why offenders get the punishment they do. Therefore, sentencing guidelines will allow public to see a transparent sentencing process at work. But whatever sentencing process, whatever sentencing guideline prepared must, to my mind, be flexible. This is to give room to judges and magistrates for the exercise of judicial discretion to meet the end of justice in each particular case. Inflexible guidelines may tie the hand of judges and magistrates. Justice should not be compromised in favor of rigid consistency in sentencing. And in our quest to promote consistency in sentencing, we must not overlook that there are many local factors which are unique to our country, as we are a multiracial, multicultural, and multi-religious society with various standards of moral probity which may not be uniform. Take, for example, the offense of incest under Section 376A of the Penal Code, which carries a sentence with imprisonment for a term of not less than 6 years and not more than 20 years, and shall also be liable to whipping. This harsh punishment, as perceived by people, enacted by Parliament, reflects the gravity, deplorable, and seriousness of the offence. But for the natives of Sarawak, for example, referred to as Land Dayak, the punishment for incest under their customary law appears to be mild and is not seen to be serious and grave. For example, pursuant to the Native Customary Law Ordinance, the Adat Bidaya Order 1994, a native is prohibited from having sexual intercourse with his stepmother, with his stepdaughter, and the punishment for that offence is stipulated as what? 1, a fine of 4 baskets of fruits, plus a restitution of 250 fruits, plus a gift consisting of 2 pigs. 1 shall be a boar and 2 fowls, 1 of which shall be a cock. In a case which was decided in Sarawak called Lakin Dalim Anak Great against public prosecutor, the court held that our judges and magistrates have to take into consideration local factors, the native personal law and punishment in considering the appropriate sentence, as judges have wide discretion to deal with sentences provided it is done with the accepted judicial norms. The other point that I want to make about this sentencing proposal is that it must be viewed in the recent amendments to the Criminal Procedure Code, which came into force on 1st of June last year. First, we have the new Section 172C of the Criminal Procedure Code, which provides a very comprehensive provisions laying down procedure for plea bargaining. The effect of this new provision is that the accused person in certain cases is able to negotiate a lesser charge or sentence opposed. And the second one is under new Section 173, which was touched by Mr. Lim in his address this morning, that before sentencing, the court is obliged to consider the victim impact statement. So these 2 provisions has an impact on the way sentencing process is done in our jurisdiction now. Now, the problems of this proportionate sentence, to my mind, and the disparity of the sentence cannot, of course, be solved by sentencing guidelines. The focal point, to my mind, should also be on continuing training and education for our judges and magistrates to ensure that they acquire and develop the necessary skill and knowledge to perform their role to the highest standard. And in closing, I would like to say that I fully appreciate that laws have to be updated and reformed to meet new and future challenges. I personally welcome any proposal or idea to improve our administration of criminal justice and to improve public confidence and faith in sentencing by our courts, whilst maintaining the independence of the judiciary and preserving judicial integrity. It is indeed the aim of our judiciary to provide a clear, transparent, fair, and consistent approach in sentencing. Ladies and gentlemen, thank you very much.
We thank you, Yang Arif, Dr. Azhar Muhammad, for sharing your personal views and experiences with us. It was indeed insightful to hear from the perspective of the judiciary on the sentencing council. Distinguished guests, that brings us to our last speaker for the day. And thereafter the Q&A session. I'm sure our last speaker, he needs no introduction. But for the benefit of you who don't know him, ladies and gentlemen, he has been an advocate and solicitor for the past 34 years. He read law in the Lincoln's Inn and was called to the English bar in 1978 and subsequently to the Malaysian bar in 1979. He was the past chairman of the Penang Bar Committee and a past member of the Malaysian Bar Council. He was also the past chairman of the Criminal Law Committee of the Malaysian Bar Council, where he continues to be a member to this very day. He is an adjunct professor of law at the University Utara Malaysia, UUM. He was also recently made an honorary assistant commissioner of police by the Inspector General of Police of Malaysia. Distinguished guests, may I please have the pleasure of inviting Dato' V. Sitambaram on stage to present his presentation.
Good evening. I am honored to present this paper, which I consider perhaps a lawyer's perspective. The caveat is not necessarily the Bar Council's perspective. I took the cue from Yang Arif. I thank the chairman of the Malaysian Bar Council, who I must say single-handedly was behind the idea of the Malaysian Bar being involved in a dialogue of establishing a sentencing council in Malaysia. I thank Professor Ari Freeberg for enlightening me of what a sentencing council and sentencing guideline and what it really means in the administration of justice. I was completely blind. I just thought we all were going to sit down together, drop a few numbers and hand it over to the judges and go home. So that's what it's all about. But I realize it requires great study. I thank Yang Arif Dato' Azhar for giving the judiciary's perspective. I thank and welcome the judges of the Court of Appeal, the senior assistant registrars from the Federal Court, Court of Appeal, High Court, session judges, who have taken time to be here with us, because this concerns all of us. It doesn't concern the accused, the police, but it concerns us, so that we have a society where we can come out of our house without having to look out and watch out, as in many neighborhoods you would have seen in other countries. I also thank the police, being represented by the OC of the KL courts, ACP Punusami, and all members of the bar, and media, and NGOs, and all my fellow friends and ladies and gentlemen. I was just reflecting. Sometimes it's quite difficult to be the last speaker, because virtually everything you have written, which you read from several sources, have all been used up. So most of the quotations have also been used up. So I was just sitting and thinking, in the last 34 years, as a lawyer, how did sentencing take place in the Malaysian courts, and in particular in the lower courts, I mean? We pay a great deal of attention, I must say that, of lawyers, prosecuting officers, and DPPs on getting a conviction. I mean, everyone prepares in the defense of the case, the prosecution of a case. But when it comes to sentencing, it is not an important factor. I must say, it is important, but somehow in our psyche, in our administration of justice, it does not appear to be important. At the end of the case, say for theft of a chicken or theft of anything, a theft case, all that the lawyer will stand up and do is, my client is a first offender, he is working and earning $1,000, he is married with 3 children, one is disabled, he's got an aged mother, all of them have aged mothers, some of them less aged fathers, aged mother. He promises not to commit the offense again. Well, I'll tell you, this is a very gallant effort. I'm not condemning the prosecution, but what the POs will do is usually a one-liner. I ask for a deterrent sentence, or I ask for a satimpal, appropriate sentence. Worse still, as Yang Arif just pointed out, I leave it to the court. And I know some judges will ask, especially High Court, what are you leaving to the court? Because you've left nothing. So this is the real scenario. I mean, let's face it. Since we are here for a dialogue, I think it is this attitude by lawyers, law enforcement, DPPs, that has led to the problem the judges face. Because we have not taken the study of sentencing something serious. If you go to the High Court and Court of Appeal, you would see a bit more is being done, because I hate to say maybe they're paid more. That shouldn't be the case. But there is a bit of comparative study. There will be a prevailing sentence practice. They will say that in the last 4 cases, this was the sentence in this case, and they'll say our case falls under the lower category. Some sort of guidance is given to the court. But now with our courts being centralized, especially the Court of Appeal and Federal Court, unlike the magistrates and High Court, I think all judges know roughly what is the going sentence. It's no more like in Australia in very many states. It's all at one building. So I think there is some sort of consistency. But only yesterday we read in the Star, which has been very vocal, with Shaila Koshi, very often picking up issues on sentencing. The Star yesterday read sentences that just do not make sense. Read the Star newspaper. Disparities have made the public worked up. And then they said something hopefully is done today. But there are detractors for the formation of a sentencing council. They say, whether rightly or wrongly you judge, that this is a knee-jerk reaction, like many things in Malaysia. Just because there was a public outcry over the binding over, Professor, binding over means suspended sentence. And somehow the Malaysian public thinks, if you get a binding over, you're just walking home. No, for the next 5 years, if you commit any offense, you will be called back and punished for the very offense you were bound over, plus for the new offense that you committed. So this is educating the public. It's just not walking over. The government is giving a probationary period, or rather the court is giving a probationary period if you have good behavior. But you will be sentenced for that very offense if you commit another offense, for both the offenses. So, because of that, they say we are now reacting to the formation of a sentencing council. Of course, the politicians, including the Minister of Law, have to react to the public's outcry. And they said that they would, in principle, consider the setting up of a sentencing council, all to ensure a consistency in sentences that are meted out by the courts. The Bar Council hailed this move, but the Bar Council had one caveat from all the statements I read. They were against any mandatory sentencing, but I must say though, that if you have a mandatory sentencing guideline, then it's no different from mandatory sentencing, because the judge's hands are tied. Instead of tied from 1 to 3 years, you just tie them maybe for 1 year. You are still tied. And it is common trend, not something disturbing, but perhaps something that as public gets more aware, NGOs and media, when they perceive a particular sentence is inadequate, then there's some amount of sometimes judge bashing, sometimes prosecution bashing, sometimes defense bashing, to say that something is wrong in the system. That is a wake-up call for us. As we all know, criminal justice system is implemented for the public, and they must be able to have confidence in the system. Of course, when I say the public, it has to be informed public, because somebody can just wake up and just pass a comment and move on. They have absolutely no clue. And judges, of course, unlike the lawyers and perhaps even the AG, we can respond. They can only respond when the judgment comes out, and usually sometimes it's 2-3 months later. So the only thing I can think of, if something controversial, you must come out with the judgment before you hand down the decision. Otherwise you'll suffer 3 months or 4 months of backlash. And as I say, most of the quotations have been used up, but this is important, that the public have a public response to sentencing is a legitimate expectation. And judges and the public, judges have to meet out with this expectation. Otherwise, we all know what will happen. There will be outcry, and then Parliament will say, here we are, the discretions are not being exercised properly. We will now introduce mandatory or minimum sentencing in any particular offense. Although we always say that our courts have long time since progressed from an eye for an eye and a tooth for a tooth type of justice, and that the courts do not sit to hand the victims of aggression their pound of flesh, but generally to protect society by enforcing justice, families of victims sometimes, understandably, do expect a pound of flesh. You can understand that. Therefore, it is in this respect that perhaps, again, another setback is we have a lot of judgments. Again, when we take, just like I say, what we lawyers do, I think I'll have a criticism of the judges. They will write a long judgment of 30 pages on conviction. When it comes to sentence, it will last just one paragraph. So I think psychologically, there's not much being done to debate why a particular sentence is being carried out. Sentencing guidelines, as understood in England or Australia, are not something very familiar to our turf. So this is something perhaps, as times changes, we have to change with time so that we are relevant. Our justice system is relevant to the people and the public confidence remains. And then another important aspect, as pointed out or stated by Lord Justice Lawton, is this, a very important quote, that one of the facts of life is that there are some offenders for whom neither deterrence or rehabilitation works. They will go on committing crime as long as they are able to do so. In these cases, the only protection which the public has in such a case is to lock them up. But for these kind of decisions to be arrived at, there has to be statistics available, the rampancy of the offense before a sentence of this nature is passed. I just picked up a few quotes from our judges because that reflects the thinking of our judges. Not very many, I can tell you, of how a sentencing process should take place. As Yang Arif before me said, sentencing of offenders, as pointed out by Justice Wan Yahya, I must say a very compassionate judge. You can see the compassion in his writing. He can almost oozes out. It's a complex and discerning process which depends not on the use of common mathematical yardstick, but on various considerations of facts and circumstances relating to the offense, the offender and public interest. But what America has done is, it is a mathematical yardstick. But in Malaysia, in our jurisprudence which we are developing, which will continue to develop, mathematical yardstick and telling a judge that this is what you do is not on. At least this is what our judges say. And I found a very old judgment which is quite interesting. Luckily no one picked this up, so maybe it'll be refreshing. This will be refreshing. This is by the then acting Chief Justice in 1954, Brown CJ, acting CJ. He said, any tendency to standardize punishment of any type of offense is to be deplored, because it means that the individual offender is being punished not upon the facts of his particular case, but because he committed an offense of that nature or that type. So all these quotations will illustrate the complexity of sentencing a particular individual. And now a proper sentence is not just decided by a judge and accepted by the offender, but it's a matter of public debate. And therefore, a sentencing guide council or some sort of ad hoc sentencing guideline or some sort of sentencing trend, we can do anything, but there has to be one that is made up of present serving judges, retired judges, police officers, lawyers, prosecutors, NGOs, the media, sociologists, all have to get together and perhaps have a sort of a council, whether it's an act of parliament or not, doesn't matter, to look into certain offences. We cannot be overtly trying to achieve it all. Perhaps you have to start off with the most serious offences and then work your way down. I'm sorry, I have to take a bit of water. This table is certainly not friendly. Okay. Because the criminal offences are very broadly defined, you'll see in Malaysia, and can have different levels of seriousness. For example, someone who steals a chocolate from a shop and someone who steals diamond from a shop will all face the same section. So both are tapped. Both of them might be, say, 25 years old, but one guy is stealing chocolate, maybe he's hungry, and the other guy is purely greedy. So, you know what I mean, it becomes difficult. So therefore, it is important to ensure that the courts across Malaysia, I would say, and advisedly, fairly consistent in their approach to sentencing. And sentencing guidelines which set out the decision-making process for all judges and magistrates to follow must play an essential role in this. The Sentencing Council will be responsible for preparing and monitoring sentencing guidelines with the aim of ensuring greater consistency in sentencing. Absolute consistency in sentencing should not be expected, because that will be most certainly at the expense of justice itself. And many areas have been touched, but it's important to remember that this guideline must allow for discretion of judges. Guidelines are intended to create a consistent approach, and within that approach, judicial discretion must be preserved, and guidelines must be treated as guidelines. And I'm skipping many pages because many of them have spoken on these topics. So therefore, it is my humble view that the Sentencing Council in Malaysia must be set up not necessarily by an act of parliament, or if that is slow, by the Chief Justice of Malaysia, who has the head of the body that dishes out or hands down sentences, and initiate and facilitate the formation of a sentencing council to assist the courts by formulating sentencing guidelines to further enhance public confidence in the criminal justice system. There are advantages of the sentencing council and there are disadvantages. You all have heard the benefits of a sentencing council, namely it reduces unwarranted sentencing disparity, eliminates unwarranted disparity among similarly situated accused across the country. But quite importantly, I think our courts sometimes do not take notice. We all sentence a lot of them to imprisonment. If you go into Penang prison, which I'm familiar with, a room which is meant for 2, now there are 16 fellows inside, with a toilet in the center. So you will find that a sentencing council will be able to study what is the prison population, whether we need additional prison, or whether sentencing prisoners to offenders to prison actually serves any real purpose. These are the studies that can be undertaken by the council, and sentence indication scheme is already in place, which is basically a plea bargaining system. Baseline sentence or minimum sentence is there, and what is important about these guidelines will be ignore things like race, economic status, I may add political status of the accused. This will help limit undesirable sentencing disparity. I can go on and on about it, which you're all aware, but let's look at, since we have looked at what are the advantages, I want to discuss some of the disadvantages. It reduces the sentencing process to a simple mathematical formula, like in America, to a lesser extent in UK. America is the extreme, UK is the medium where there is some discretion, and in Australia is very loose, I would say. So the professor has to keep going to get them closer to England. Yeah. The mandatory sentencing guidelines create a structured sentencing by setting numerical formulas to calculate the imposed sentence based on the type of crime, the criminal history of the accused, the specific offense factors, the quality or quantity of guns or drugs, whether anyone was injured, etc. And sentencing becomes too impersonal and mechanical. Sentencing guidelines become improper incursion into the judicial discretion. There is no flexibility, discretion, and judgment in sentencing. Basically, the human process is absent. The rigidity can result in injustices in individual cases. So these are some of the disadvantages. And as was pointed out by Yang Arif, Dr. Azhar, we have a practice direction which is almost equivalent to a sentencing guideline which was issued by the federal court in the year 2012. It only covers sentences, cases where the sentences are from 14 years to 30 years. And this guideline was issued because of our amendment to the CPC, which is the Criminal Procedure Code, where if you now plead guilty, you get an automatic, with certain exceptions involving children and sexual offences, etc., you'll get a 50% discount to start with. And thereafter, there is certain guidelines provided for the type of sentences that are to be given. Of course, this guideline, I have dealt with it in my paper, just gives you the numbers. It does not go on to give you the reasons or justification for any particular sentence or length of imprisonment. It does not show whether any studies were conducted, etc. The guideline is silent as to the weight to be attached to various factors, mitigating factors, and the guideline is also not divided into different levels of seriousness. But quite to be fair to the guidelines, I think the guidelines were issued just for numbers as a guidance. It was not done something like what we are having in mind. Sentencing guideline, which is more to do with the in-depth study of the various other factors involved in sentencing. But from reading of the various sentencing councils, I picked up there were at least 3 or 4 challenges faced by the sentencing councils. One is the members of sentencing council did not have the kind of criminal experience that was required in many jurisdictions. None of the sentencing council members had experience in sentencing offenders in a high volume court, nor was there a private defense lawyer or a probation officer or a criminologist, psychologist, etc. And then the sentencing council membership tilted in favor of public interest, prosecution interest. The sentencing council did not conduct deterrent studies, consider efficacy of a particular treatment program, or evaluate guideline impact on crime control. These are some of the criticisms found in other jurisdictions. Of course, I've done a study on the guidelines in USA. Of course, you'll find that it's very restrictive, and there has been challenge to the guidelines, at least the federal guidelines, and they remain guidelines, but somehow they seem to have almost assumed, although they say it's guidelines, the courts are expected to follow the guidelines. We always quote one case when it comes to, at least those days, nowadays nobody quotes this case anymore, but this is a very good case which the judge read part of it. This is R versus Kenneth John Ball, or R versus Ball. Actually, it is a very, very important piece of, it's a very important case. It is a case decided by the Court of Criminal Appeal of England by a 3-man bench, but a judgment was handed down by Justice Hilbury. And in view of the importance, I'll just read it slowly for us to sort of take stock. In deciding the appropriate sentence, a court should always be guided by certain considerations. The first and foremost is public interest. The criminal law is publicly enforced, not only with the object of punishing crime, but also in the hope of preventing it. A proper sentence passed in public serves the public interest in two ways. It may deter others who might be tempted to try crime as seeming to offer easy money on the supposition that if the offender is caught and brought to justice, the punishment will be negligible. Such a sentence may also deter the particular criminal from committing a crime again or induce him to turn from a criminal to an honest life. The public interest is indeed served and best served if the offender is induced to turn from criminal ways to honest living. We have heard this many times, but it's the second part that is something that we have to consider in the light of whether we want a sentencing counsel. And this is what the learned judge continued. Our law does not therefore fix the sentence for a particular crime, but fixes a maximum sentence and leaves it to the court to decide what is within that maximum the appropriate sentence for each criminal in the particular circumstances of each case. Not only in regard to each crime, but in regard to each criminal, the court has a right and duty to decide whether to be lenient or severe. So you would see this case goes, if this is correct, then we cannot have a sentencing guideline because you are narrowing. Now, if a sentence is up to 10 years, the court can pass from 1 day to 10 years. Or in some instances, we have cases where from 1 day to 30 years. There's something which I don't agree in Malaysia is whenever there's a public outcry, Parliament will respond by increasing the sentence from 20 to 30 years. If there's another outcry, it will come from 30 to 40 years. I mean, in any society, if you were to lock somebody up for 30 years, and as I recall, there was in the Malaysian law conference, Mr. Lim will recall, Zaman Khan, who was a CPO, and then he later was involved in the prison, he actually gave a talk and he delivered a paper. He says most people, unless they're very hardcore, 5, 6, 7 years, they're all already ready, looking forward, if given a chance to come out, lead an honest life, they have learned. Of course, there are always a few rogues. You cannot, because of the few rogues, keep 80% of people who deserve to come out. But in our law, for many offences, the sentences have been increased from 20 to 30 years. It's worse than what used to be a life sentence, which was up to 20 years. Now that also has been amended, I guess, and drug cases to 30 years. So when such discussion for drug cases is between 5 to 30, 25 years is the gap. So how does one decide from a young individual who commits the offense, if it's for personal consumption, or some guy will say his mother is dying of cancer, he did the trafficking. Another guy who has done it 6 times, gone all over the world. So there's so many varying the type of drugs, whether they are professionals, they are otherwise. So many things have to be taken into account. So a sentencing counsel and the guidelines, while providing the guidelines, will always provide an escape clause for individual cases. That must be so. Therefore, I am of the view that a sentencing counsel, by issuing sentencing guidelines, reduces the freedom and discretion of a judge to choose an appropriate sentence as envisaged in R versus Ball. So, a sentencing counsel must be established by an act of parliament as demonstrated in other jurisdictions. But as they say, no guideline is infallible. You can have the guideline, as the professor pointed out. Within the guideline, then like in America, they have a guideline, and within the guideline, they are now arguing what should be the proper. Instead of arguing the merits of the matter, they are arguing only whether it's within the guideline, as if it's sacrosanct. Whether it's a perfect set of figures, facts and figures. So no guideline is infallible. And just to share with you, I just got hold of the sentencing counsel on England, just a few minutes. This is for offence, say, for causing grievous bodily harm. Because at least you get a rough picture how they work there. I think it is a more moderate way of looking at things. Step 1, this is which is equivalent to our causing grievous hurt under section 326. It's an equivalent section. They'll have step 1, they'll determine the offence category. They'll have category 1, category 2, category 3. Great harm, i.e. where there's serious injury or higher culpability. Then great harm, lower culpability. lesser harm, lower culpability. Then factors indicating greater harm, where victims are particularly vulnerable. If you go into an old lady's house who's staying alone and you go and attack her, as opposed to walking into perhaps a factory where there are many workers, etc. And then there will be factors indicating higher culpability, premeditation, use of the type of weapons, the intention to commit the offense, whether it's by a gang or a group. And then for lower culpability, whether he's a subordinate in the group, whether he acted because of provocation, lack of premeditation, etc., etc. So what they have set out to do, and then for each, then step 2, they'll have category 1, 12 years custody, category 2, 6 years, category 3, 4 years. Then factors increasing seriousness, location of offense, timing of offense, ongoing effect upon the victim, offense committed against those working in public sector, for instance against the police, etc. So, and then mitigating, it's a single blow, remorse, good character, etc., etc. It goes on. And then step 3, they'll consider any other factors which indicate a reduction. Step 4, reduction for guilty pleas. Step 5, how dangerous was the offense. Step 6 is a totality principles, assuming he is already serving some term for 20 years, and you won't give him another 20 years, you might as well, finish him off. And step 8, the judge has to give, the duty to give reasons and explain the effect of the sentence. And this is where the public will be able to appreciate. And step 9, consider the remand time that he has spent. So you can see there is a logical sequence, and all the mitigating factors that we can possibly think of, they put it in various categories, and then they give a range. So this is something that is reasonably workable, I guess. But ultimately, before I end, I only wish to say this: no guideline is infallible, and the ultimate responsibility of whether there is sentencing guidelines or otherwise remains with the judges, and lawyers and prosecutors have the role to play in bringing up sentencing trend and making, as I think one judge said that it is our duty, that the mitigation speech is recognized as a very important piece of speech. This is actually from one book, and that the advocate or DPP should equip himself properly for his task of representing his client or for the state and helping the court to come to a correct conclusion. I think that is where we lack. That is where we lack. And our present state of mess that is in sentencing, or disparity, I would say, not mess, disparity and unhappiness is our own doing, and let's all wake up and do something about it. Thank you.
Thank you, Dato' Chidambaram, for your full and frank presentation and in sharing your personal views, and thereof as a practicing defense lawyer with us today. Distinguished guests, ladies and gentlemen, we now come to the final session for the day, which is the Q&A session. We want to take a short break, or I think we start straight away, and then we'll have the break later towards the end of the day. May I please have the pleasure of inviting the esteemed panel to be seated on stage. May I please invite Yang Arif Dato' Azhar Muhammad, Professor Ari Freeberg, Dato' V. Chidambaram. This Q&A session will be moderated by Mr. Rajpal Singh, Chairperson of the Criminal Law Committee. There will be an open session of Q&A, so this is a time that any doubts that you've been harboring and has been lingering in your thoughts and minds since morning, it's a good time to pose your questions now. We will be passing the mic. The Bar Council, the staff will be holding the mic in the center and one will be in the front. So please raise your hand to get his attention so they can pass the microphone to you. Mr. Rajpal, thank you.
Thank you, Ahmed Pan. Okay, I'll open the floor for questions. I think we take about, since we got time, we take 2 questions at a time. Right, so anyone would like to start off? We need someone to get the ball rolling. Yes? Can you just state your name?
Good evening. My name is Richo. I'm from Women's Aid organization. Thanks so much to all the speakers for enlightening us on this important topic. My question is, quite simple. How would the council go about writing these guidelines for various issues, and what would the process of, would there be a process of consultation, say with NGOs and public?
Professor Ari should be the right person to answer this.
Okay, it's a really important question. It depends on the kind of guidelines that you want to have. And as you've heard from the previous presentations, there are different models. There's the UK model, which are a combination of narrative, describing the steps you need to go through, plus some numbers as to high range, medium range, low range. In New Zealand, there was a lot of work previously done to create a comprehensive set of guidelines in which there was very little public input, but a great amount of work done by the Law Reform Commission. In the US, and by the way, can I say the US has got 24 different guideline systems. The one that we focus on is the federal guideline system, but there are state guideline systems which are more or less binding and more or less specific. In those cases, you get public input through sentencing councils and the work then done by the Sentencing Commission. In Victoria, the process I outlined related to a Court of Appeal which requested a guideline, which then required the Sentencing Council to prepare a draft guidelines. That involved consultation with the public as to what the guideline should be. It's returned to the Court of Appeal, then an adversarial debate about the guideline, and then the Court of Appeal deciding with a bench of 5. So it depends on what system you choose in this country should you go ahead as to the kind of guideline and the process. And that will then determine what level of public input there would be.
Thank you, Professor. Any other questions?
Yes, I have. My name is Mei Leong. I'm a practicing lawyer. There's one question that is in my mind. I always think of sentencing. The end result of sentencing, or the end goal of sentencing, is transforming society into a righteous society. This is what I've always hoped for. Yeah, but as Dato' Azhar has said, we uphold the rule of law, we follow the law, we do all these things. I just want to know for judges, when you give a sentence, I'm sure this is also part of your something is in your mind to transform society. But as members of the public sees it, like snatch thief, for example, we have very heavy sentences that is being passed for snatch thief, but we don't see a decrease in this crime. Instead of motorbikes, now they use cars. And that's why I'm just wondering, how is this sentencing, sentencing for this kind of things? What kind of things must a judge do to give the right sentence to transform society? And for Professor Aris, I would like to know what is the success rate. For you have this sentencing council of the guidelines. Is transforming? I'm sure transforming society is one of the agenda, but how successful had it been? In transforming society. And then the other question I have is the public perception of disparity. You say unwarranted disparity. As you know about this case concerning the rape, the young boy was raped and then was binding over. I have the opportunity to actually get opinions from the young people when this case came about. And I asked the young people, do you think the judge is right in giving a binding over? It's very surprising to me that young people think it's okay. It's okay, because in their generation, now, sex is quite okay, The ones who object to it are the mothers who have daughters. They say, no, we must enforce the law, we must get this thing. And when I ask the men, they are a bit quiet. So these are the disparity in the response of the members of the public towards an issue on sentencing. So how do we reconcile it? How does the Sentencing Council reconcile this kind of disparity? Because you say you have to do research. I'm sure in any subject, in any issue, the disparity is quite clear. The response of the public, like you say, even the judge, one judge would sentence this way and then the disparity is just too much. So how do we bring this disparity to close up, to be united, if I may use the word. That's my question.
Probably, Yang Dato can talk about the transforming of the society.
I think your views and your question demonstrate really how difficult passing sentence, for us judges and magistrates. Well, I think for when we judges pass sentence, there is always the aim, of punishment. Of course, at the back of our mind will be number one, to punish the offender, right? And number two, maybe for reform. Whether the aim is to punish or to reform will very much depend on the nature of the cases. For cases like robbery, persistent offenders who have been committing the offense, and I think maybe the issue about reform doesn't apply for that particular offender. He has to be punished for the crimes and also as an example to other would-be offenders. Right? But when you talk about reform, I suppose you look at reform to to rehabilitate, to reform the particular offender. That would depend very much on my personal view. Cases, for example, involving a young offender, juvenile, and of course cases like involving there's no violence involved, cases where there is issue of moral rape cases. And these are kind of offenses where I think the issue of reform, I'm looking at a more individual offender, will be very relevant. This is where I think when you talk about sentencing youthful offender or offender for statutory rape, it is a very, very difficult kind of offense for judges to pass an appropriate sentence. You see? As I said, you mentioned about the case of statutory rape involving a young offender who has a consensual act with his girlfriend. You see? I had a similar thing on Friday. Last Friday, I was mentioning a little bit about that case. The counsel who happened to be, it's all right, Mr. Ahmadi, because this is the end of the case. There's no substitutes here. He stood up, and said that this case, the facts and the circumstances are similar to that case. No visa case. The offender was 21 years of age. The victim was about 12 or 13. Happened in the hotel. Right? And so here we are. But there is one distinguishing factor which we thought that we can differentiate of that case. You see, when a judge pass sentence, one of the important mitigating factors will be this, He pleaded guilty, the offender pleaded guilty immediately. That will show dia dah tobat kan, dia dah menyesal. That for us, for judges, is a very important factor. Right? But in this case, and that what happened in North-Africa case, isn't it? He pleaded guilty. Right? So he now asked for what? Forgiveness. So I think that swayed the court. But in our case, in the case that I had to decide, the kind of three judges, was this. What has happened in that case actually, the Sessions Court acquitted him, the High Court acquitted him, but when come to the public prosecutor cross appeal against the acquittal, and when we evaluate that, we come to the conclusion that should be convicted. Of course, that's another question. But when we come to sentence, that is the distinguishing factor, because unlike North-Africa case, there was no that sense of to us, that sense of remorse. He came quite late. Of course, in his mitigation, it was quite late. Well, but even though he said that he has repented. So that shows, case varies from one case up to another and compared to another. So,
Thank you. On the next question, what's the success rate of sentencing counsel in transforming society and the disparity of sentencing and whether it's reconciled?
Your question is a very large one. I don't think any council in the world could claim to transform society. I don't think even Parliament can transform society. So we don't claim to do that. And I also take issue or just question about the role of sentencing to create a righteous society that has interesting overtones about the nature of a society that you want to have. I could certainly defend the ideal of a just and safe society, what that means. Righteous is not part of the legal discourse, I think. But to what extent do we introduce change? I think that's an important question. And you raise some interesting issues about what are the effects of sentencing. And I think what we have very often in sentencing is a lot of anecdotes about what works and what doesn't. And as somebody once said, the plural of anecdotes is not research. That is, the fact that lots of people have stories does not amount to proper research. And what does that mean in practice? Well, we had raised a few moments ago the parliamentary or political response to prevalence of crime in terms of raising maximum penalties. There's no evidence at all that raising maximum penalties deters crime. It may deter voters from voting against you. It's a political response, it's not a criminological response. All of the evidence is that certainty and speed of detection are the major factors that are affecting people's contemplation of crime or commission of crime. Now, we did a paper at the Sentencing Council that's on the website on does imprisonment deter crime? And we found that it has very little effect on crime. Judges say endlessly, I'm imposing this sentence to deter others. The paradox you find is that those who are most in need of deterrence are the least likely to be deterred by what the judges say. They don't read the newspapers. They don't sit around saying, did you read that latest case in the law report where the High Court said something or other? They're either on drugs or they've had some crisis or they're alcohol or there's psychological issues, a whole lot of issues which drive people to commit crime. But the sentence, and certainly not the sentence length, is the factor. So you have a paradox that the simple solution of increasing sentences, whether it be by Parliament or the court, is not what will be effective. What we need to know is what will be effective. So if you have a look at our paper on does imprisonment deter, I have to say that the government in Victoria did not like that particular report. I don't think many of the judges liked it either, because it is a ritual to say, I'm imposing this sentence for the purpose of deterring others. The scientific evidence is not there. So we need to know what works and what doesn't. A sentencing counsel could do that. Criminologists can do that. The courts don't have the capacity to do that. One other issue you raised about disparity of public opinion. Now, with all respect to your methodology, I'm sure that you spoke to a stratified random sample of the Malaysian community, talked to at least 120 or 150 people to get a fair background of these people, talked about their demographics, their age and the like. Unless you did that, then what you have is a series of impressions about what the public opinion is about that effect. That is not science. What again we've tried to do in the council is scientifically sample public opinion to find out what the public thinks of certain sentences, thinks of certain offences, thinks of certain principles of sentencing, and we do that usually by a quite comprehensive questionnaire, and we try to get a fair random sample of the community. So it's important that judges and politicians don't respond by laws or by judgments on the basis of what they think the public believes, unless you really know. And the public only really knows partly through a process of explaining what the system is first, and then having a proper survey process. Can I say one of the most interesting studies that's occurred in Australia, and we're now repeating it, that happened in Tasmania, is to get jury members, that is people who have sat through a trial, to participate in a questionnaire and then an interview as to what they thought of the sentence and the process, having heard all of the material in the trial and then been asked to stay back and listen to or be told about what the judge did and then find out about the sentence. And interestingly, in those cases, the difference between what the judge did and what the jury thought was appropriate was not very much indeed. That is, they tended to agree with what a judge did. That is, the more information people have about what judges really do, the more agreement they have. A lot of people lose confidence in the sentencing system because they don't have the facts of the case in front of them like the judges do. So my answer is, we need to know more about what works and what doesn't, not just bald statements, and we need to understand what the public really believes in sentencing. And again, we've done many studies of that, but your question's a very good one. I hope for a righteous society, but not tomorrow.
Thank you, Professor. I think Dr. Sidam has something to add on.
Sorry, I think in Malaysia we know that the death penalty has not reduced drug trafficking because there are more guys awaiting trafficking cases in courts than before, despite the high disposal of cases by the high courts. And also, some time ago, is there a fire bell? No, okay. Some time ago, the Singapore government, what it did is it was conducted comparing reported cases of housebreaking during a 4-month period prior to the introduction of a minimum imprisonment sentence for housebreaking. And the reported cases of housebreaking for the same length of time after the legislation came into force showed a marked increase. So the fact that you had a minimum sentence didn't mean a thing. And in fact, there is a little literature from a book which says there is little evidence that the amount or rate of crime is so related to sentencing policy that it's dependent upon and varies with changes therein, the fact that you change the type of sentencing. By contrast, there is much evidence that the volume and rate of crime are influenced by factors beyond the control of the penal administration, such as the length, strength and efficacy of the police force, the economic status and the stability of the population. These are the root causes, so we are now dealing with the tail end.
Thank you, Dr. Sulaiman. Any other questions?
Got a question here, Mr. Rajpal. Professor, you mentioned that in Victoria, you've had a sentencing council. Yeah, you've had a sentencing council since 2004. Has the fact that you've had one since 2004 in Victoria resulted in less public complaints about disparity in sentencing in Victoria?
We don't have any baseline figures about public complaints. It's quite interesting that a lot of it is event-driven, and a lot of it is driven by some sections of the media. That is, the pressure for change comes from a tabloid newspaper in particular. Interestingly, the journalist who was a major writer for that newspaper, who produced quite a number of the references for us when he suggested there were problems with the law, is now sitting on the council. Now that he's come off being a journalist, he's now on the other side. It's difficult to know whether the level of public complaints has decreased. I think what changes is the sensitivity of the government to those complaints and an understanding of whether they should respond or not. If they should, what happens. So there's no baseline that we can't measure by letters to the editor or phone calls to the radio, or they don't come to us. So I can't tell you empirically that they've gone up or down. It's just impossible to tell. Public confidence is very difficult to measure.
Thank you, Professor. I think Renuga, you had a question for me.
Done? Yeah. So my question is, and it's directed to any of our panel members. I'm not sure if Professor will be able to add to this. Do you think that, does the panel think that perhaps here in Malaysia, it's more likely that a sentencing council, if ever set up, is likely to be made up of appointees by government or the judicial and legal services? Or is it more likely to be perhaps something akin to Suhakam, where they are appointed independently from perhaps members of civil society? And the reason I ask this question is, I have concerns that if, for example, it is another council appointed entirely by government, it might end up being yet another nail in the coffin that's dispatching individual rights. Here in Malaysia, with high levels of corruption, a little, hardly any accountability for the police force, and long periods of time between when cases are heard, I have concerns that the individual's rights will yet again be, I suppose, diminished because of the fact that there's yet another government-type body that will decide what the punishment is likely to be. That's my concern.
Okay, basically your question is, if they decide to have a sentencing council, who should sit in it? Yeah? Anyone would like to answer that?
Needless to say, I'm quite happy to answer that. I think it's a really important question. I talked earlier about the independence of a council. If you have a council stacked with government appointees, and by that, look, we're all appointed by the government, so it's very difficult to find another process by which this can be done. It's the question of the integrity of the process. It was mentioned before that one of the possibilities was to have the Chief Justice set up a council. I think, with great respect, which means I don't agree, of course, with great respect, that a council that's a creature of the judiciary is not independent. In the same way, a council that is a creature of government is not independent. Such a council will lose credibility and become irrelevant. So you saw on our council we had 15 people. There were no members of the judiciary, which I personally don't agree with, but my council members wanted not to be influenced greatly by the judiciary, who have other ways of expressing their views. I think we should have some members. I think they bring enormous experience. But the voices of victims, the voices of corrections, the voices of prosecution, the voices of academics, the voices of members of the public, who need not, may I say, be experts. The point of this is not an expert body, it's a broad-based body which can bring the experience of life to bear. So all I can say is the appointment process and the integrity process. By that I mean, if a report comes out which is not welcomed by government, people can't then be summarily dismissed, or the council then just abolished because it's uncomfortable. So independence and a wide range of people and integrity are key to any council. The balance will change, but you do need to have a wide range of voices, and those voices must be expressed through the reports, through the consultation, and through the understanding of the public of what that council does. Otherwise, it's just another irrelevant body. Great question.
Yeah, leave that too.
I think if Malaysia were to set up a council, the first question then would be, what would be the function of the council? That, I think, will have a bearing on the composition of the members. If the council, the main function of the council is merely to issue guidelines, such as maybe UK, then the composition I would say would be those who are directly involved in the administration of criminal justice, those judges, lawyers, prosecutors, and those in the prison authorities. Right? But if the functions of the certain council, such as in your jurisdiction, you say in Victoria, where you don't have, in fact, issue guidelines, then perhaps the composition would differ, you know. Perhaps more academician, I don't know, because you actually undertakes research, doesn't it? So that will depend very much what will be the functions of that council, the private.
Okay, I think that will answer your question, Jennifer. Yeah, Rao, what's your question?
Very good afternoon, ladies and gentlemen. My name is Rao. I'm a practicing lawyer. Just want to ask this question in regard to the sentencing council. I believe, it's my personal view, that it is more appropriate that it functions at the lower courts, meaning that at the magistrates court level. The reason being because most of the new magistrates come into the system at that stage. Now, I have experienced new magistrates meting out sentences which I deem to say ridiculous. We do respect. Purely because maybe it's inexperience, or maybe they are caught by the offense and they are led by making a decision which is not in favor of what we call a fair sentencing policy. For those judges who are already in the Sessions Court, High Court, Court of Appeal, Federal Court, I think that experience dictates that this sentencing council or whatever proposal that we are coming out with matters much. Simply because they have the experience before them. And I can vouch for that because I've appeared before many good judges who have given very sound judgments as for sentencing. Now, the problem lies at the lower courts, magistrates court. Now, when we have this sentencing council, we determine them or we look at it being a guideline. Now, these guidelines can sometimes cause problems for practicing lawyers and clients for the matter. The fear of whether once a sentence has been meted up, would that be or would there be an appeal as against that particular decision? Now, I have come across personally that most magistrates, with the burden of work, I have to admit, they have about 20 cases to dispose minimum a day. Now, time factor. The process of sentencing must not be a mechanical process. It's a myth. I'm sorry to say that. They have no time to go through that particular process of hearing a mitigation for half an hour. It's impossible, it doesn't work. If I'm seen to be wrong, come down to the ground and see it yourselves. It's impossible. So therefore, I do believe that this sentencing council is more appropriate, whatever guidelines there may be. I'm all for progress. It suits that lower courts better than any other courts. That's number one. Number two, would this sentencing council, the guidelines given, if we are successful going that far, would eradicate that fear to the deciding magistrate that he has the right to impose that sentence without any fear. Because most of my problems lies that, would that be an appeal? The judge or the magistrate may say, I'll give you let's say, I'll give you a bound over, for example. Would that decision be overridden by the appeal when it goes to a higher judge? That's number one. Number two, now, we have been harping, it's been a hot topic, no Rakizal's case. Now, there were a panel of judges in the Court of Appeal, in their wisdom, decided that to give a sentence, an order of bound over against the accused. Now, public sentiments ran high. People said that it's a wrong decision. But if you were to ask me subjectively, there's nothing wrong with the decision. It's a very sound decision because I think we have read the judgment. there were issues involved in that which mandated the court to impose such an order. Now, I'm not going to try to say that it's across the board. No. Hardened criminals, they deserve harsher punishments. But there are instances whereby we can compare and contrast. Therefore, I do feel that for whatever purposes, the sentencing council will operate better if it's used at the lower court as opposed to across the board. Thank you.
Okay, now, sorry, but what exactly is your question? Are you asking that it's more appropriate to have sentencing counsel for lower courts? That's it. That's your question.
That's it, and also that whether whatever that comes out of it, all right, would it be binding? If it's possible, that any decisions made is made without any fear.
So my next question is, what would be the powers of the sentencing council as to the guidelines that they come up with? Right? Anyone would like to?
I can see your point that if at all the security council, the sentencing council were to issue a guideline, it should be focused on the lower courts, the magistrates' courts, especially. And I can give two more reasons why that should be the priority. Number one, the bulk of our sentencing that is done in our country, I would say 90% or more are done, undertaken in the magistrates' court, especially, you know, and the theft case, and even all those cases that's reported, the disproportionate sentencing, all are done in the magistrates' court. And number two is that 90% or perhaps more than that are represented, you know, by the represented, and for magistrate and for me, personally, I feel that if an accused person is represented and properly mitigation is advanced, it will have influence on the way judges will give the punishment. So I think these two reasons, I think, would strengthen your argument that yes, guideline, the focal point, if at all, is to be issued to be the lower courts. On the issue whether it should be binding or not, certainly I don't think any guidelines should bind, because as I say in my paper, it should not at all tie up the discretion powers of a judge, especially to do justice, you know, because as I said, as far as I'm concerned, especially in my opinion, that when you look at cases and the punishment to be meted out, it should be the fact that it comes just before the court. So guidelines should never ever be behind the court.
I also agree that magistrates' court is where the action is. The same in our jurisdiction, 90% dealt with. That's why we presented the SAC stats. We were responsive to the magistrates who do a lot of the work, and they now have the data. Just three answers, I suppose. One is, you should view guidelines as starting points, not end points. And that's the way the process goes, so that you get more consistency by saying, in the average case, or in this kind of case, and then you can go up or down, depending on the circumstances. Secondly, there should be no case where there's no appeal. The grounds of appeal may be different. And as I mentioned, what happens is when you get quite rigid guidelines is the appeal becomes, have you departed from the guideline, not is it too high or too low, because there's been a predetermination that that is the appropriate sentence. We can debate that. The third point is that guidelines are not just about numbers, and one of the appropriate roles for a court of appeal, this is why I think it applies more broadly than just to the magistrates' court, it's not just about numbers. We should seek guidelines, or there should be guidelines as to the appropriate uses of sentences, or the principles in various offences, or a whole range of when a guilty plea should be taken into account, what weight. So there are a whole lot of issues relating to the factors and the options, or the sentences, the sanctions themselves, not just numbers. So don't become obsessed by guidelines are only about tariffs. They're about process as well. And the UK sentencing Guidelines Council has done a number of guidelines on the seriousness of the offence or the guilty plea. And I think that's an appropriate role also for a Court of Appeal under a guideline system and for a sentencing council. So I hope that sort of allays some of your fears. It should never be any sentence that's unappellable.
Overall, that answers your question. Yeah. Any more questions?
Yeah, I've got Ajit from KL. Now, my question to you is that the Sentencing Council set up the list that's given to us the first part in the morning. I see that 3 countries are actively involved, that's UK, Australia and US. Apart of these, are there any other countries into this Sentencing Council other than any other European states, countries on this on the Sentencing Council? That's one. Number 2 is that there's some criticism on the Sentencing Council where I've read, they say that the Sentencing Council is laying down policy which is encroaching on the Parliament, and there'll be issue of separation of powers. What's your view on this?
Okay, as far as I know, it's the UK, the US and Australia. As I said, so Ireland is about to get one, I think. New Zealand almost had one. I hear there are rumours in Malaysia that it might be possible as well. So the idea is spreading slowly. It's only 10 or 15 years old. And in the US there are 24 different commissions. So that's the answer. In Europe, because of the different nature of sentencing under civil law systems, there isn't as much interest in the whole problem of disparity and disproportionality. The inquisitorial system and the role of appellate judges and the role of Parliament hasn't created the same groundswell. And in fact, interestingly, in Europe, sentencing is not a hot political issue, as far as I can tell. Certainly not as much as it is in Australia and Canada and the United States. So, a different political environment. The second question, I think I made it clear that it's only advisory in Australia and in most other countries. So I don't think there's a question of the separation of powers. What happened was, in the High Court, was they believed that if the courts laid down binding guidance, that would encroach on parliamentary sovereignty. That is, they were making legislative policy and that was inappropriate. So that was what we call a Chapter 3, a division of powers issue. In the US, the Supreme Court has held that a sentencing commission is not assuming legislative powers contrary to the Constitution. So those constitutional issues are really quite important when it comes to establishing a council. I think we want to make sure that the separation of powers is maintained. And that means a clear role for government, a clear role for courts, and a clear role for the council. There's no bindingness, as far as I know, to any of these councils' work.
Thank you, Professor. Any other questions?
Professor Aris, here. Something is just on my mind. You know, the members, the constitution of the members of the Sentencing Council, you put in victims. This may sound a bit stupid, but do you consider reformed offender so that they can, since they are the recipient of the sentence?
That is a terrific question, and we have considered it. And not only have we considered it, I remember one reference where we were looking at driving while disqualified, when your licence was disqualified. And we put an advertisement in the newspaper to say, if anyone has been driving whilst disqualified, please come to us anonymously. We want to talk to you about why you were doing it, because we know that there are sometimes good reasons, like you need to drive for a job. You need, if you don't have a licence, you lose your job, which means you lose your house. And the newspaper, the tabloid newspaper, became hysterical and said, how dare you ask criminals what their views are? This is crazy. And we said, who better to ask than the people who you're aiming the sentencing at? And we found did get some people. We are having tremendous problems identifying appropriate reforms or people who can speak on behalf of offenders. We would like to have more people. I've suggested it a number of times. I'm having a little trouble convincing people that, but I think for an appropriately balanced council, having somebody who's seen the inside of prison and who understands is really, really important. And I know just the person in Victoria for that, but I can't dissuade others. But it should, I think that really should have.
Thank you, Professor. Okay, ACP Mulu.
One question, small question. You're talking about sentencing council. What is the need for Malaysia to have council? Since everybody, as Dato Sidam said, in Malaysia when we are talking about something, straight away everybody starts jumping and we come up with sentencing council now. I'm not against it. Just whether we have done any studies, what is the disparity of sentence passed in Malaysian courts that we need immediately to have a sentencing council? Thank you.
So do we need a sentencing council? That's why we're having this forum. Maybe Dr. Sidam.
This idea to form a sentencing council came from the two youths who were bound over. Literally, the two cases was the impetus for Malaysia to consider. I think there have been disparity in the past, but you're absolutely right, because you see, if you look at a day throughout Malaysia, I'm just giving you a random, probably 1,000 cases have been sentenced. And all the big courts, Ipoh, Johor Bahru and all have court reporters. If anything bad or even inappropriate happens, it will be reported. If not the same day, the following day, someone would have. So, taking a history in Malaysia, that perhaps in the last 1 year, there were 2 or 3 outrage is relatively small. Does that call for a sentencing council? I mean, that's a good question. But do we want to look at it more holistically? For as a developing nation, in line, in tandem with other countries? As I say, for having a sentencing council is not going to be like a binding precedent on the judges. In fact, if the judges want, in some areas, they can just seek assistance from it by looking at it and seeing what is the range, and then applying it to their own facts. It's no harm in having it, but whether we need it is something I think you have to ask the newspapers and the law minister, because that's how, and maybe TV and all were quite keen on this, because this is something, we have, even in the criminal law committee, there's a lot of different views. In fact, when they had a discussion, some of them felt you don't need it, courts are doing all right, do we so need one? But I think overall, it is no harm in studying whether having it may improve the quality of justice in Malaysia. Yes, GV, in defense.
I think one of the reasons why I came about suggesting the idea, and it was agreed in council, and of course we asked Dato' Sidam to draw up a paper. When you look at the criminal justice system, what is lacking is the lack of research and lack of understanding of the system. And I think you raised a very good point. Has anybody studied the disparity? There has been some study, some of the students or either masters or postgraduate have done some study, lying in the thesis somewhere in some law library, law faculty, but there's been no comprehensive empirical study. The courts themselves, of course, have their own database, but it is not made public, and then we don't sit around and engage ourselves. And I think really this is probably the first occasion that both the bar, AGC, and also the bench, we're all sitting together with a foreign expert to talk about this. And as Sidam so correctly said in his paper, this is just a start. We've got to start thinking about it. My disappointment is actually the law schools. Unless the registration missed you, but where are the law lecturers? Where are the criminologists in this area? We need to sit down and look at this together. First of all, understand the system, have empirical evidence, understand the system, the trends, and then see how to improve it.
If I may add, I think simply because we don't have a study on disparity of sentencing, we don't even know what really is happening. It's a good start to have a sentencing council to find that out on an advisory nature. I think that is the simple basis for having one. Right? Any was Salim Bashir?
Salim Bashir, practicing lawyer. I am for the sentencing council, but my concern is to allay fears of many of us. In establishment of a half-big sentencing council, and this is where the problem starts, where the judiciary will be deprived of their power of sentencing, and at the end of the day, it will result in injustice. How to overcome? Perhaps maybe His Lordship can answer.
You're saying what is not to have a half-baked sentencing counsel. So basically that's why I think before maybe Arif Dato will answer, it has to start only on an advisory nature, like what the Right Honourable Minister said this morning. But maybe Arif Dato would like to add on anything. Yeah.
I think first I'd just like to respond to the earlier question about the need of security council, such a council. So as I stated in my presentation, you see, our present sentencing process and policy, I think generally has worked well. But I think, of course, there will be always room for improvement. And I also stated in my presentation is that I personally will welcome any guidelines, because that will make my life much easier as a judge, to sentence people, you see. And then on the concern by the earlier question, your question, as I said, that any guideline issued by such a council, there must be some flexibility. It cannot be rigid. And I don't think in any jurisdiction where guidelines are issued by council, there is the hands of the judges and also even in UK, despite as I understand it, even in UK where guidelines are issued, still the concerns are being raised in the newspaper about the disparity of sentence, the disproportionate sentencing. That goes to show that even with guidelines, judges still have that kind of discussion in imposing sentence.
I think this concern is expressed again and again, and apparently as many times as one says this is not an attack on judicial independence, it's hard to allay the fears of the profession and the judges, but when they have been introduced, apart from, I think, in the United States under the federal system, where until the Supreme Court struck them down, they were very restrictive and very rigid. But nobody in the rest of the common law world, and in fact in the rest of the United States at the state level, wants to emulate the US federal system as it was. And I think that's the big bogeyman that needs to be shot down, cut up, buried, cremated, and all.
Hope Salim answers your question. Any other questions? Before we call it a day, we got another 5 minutes. Any other questions? Mr. Ahmed Pan, for MC for a day, as the last question.
Lost my question. Earlier, Dato' Amripal Singh, member of the bar. Dato' earlier, this was open to all the panels when the case of R against Kenneth John Paul was referred. Appropriately, Hillbury Justice says that a proper sentence passed in public serves the public interest in two ways. Now, the first way is the proper sentence, but then the second way is the public interest is indeed served and best served if the offender is induced to turn from criminal ways to honest living. How would the sentencing council consider this in view of the accused person's perspective? I mean, as advocates and solicitors, whenever we are in court, whenever we commit on mitigation or sentencing, we always try to persuade the court that our client should be given a more lenient sentence. And sometimes the courts are with us, and sometimes the courts are not with us. But how would the sentencing council come up with such a guideline to ensure that parties know that the accused interest is also looked into?
The question is how to balance between public interest and accused interest.
No, the accused interest.
Yeah, accused.
How would the sentencing council look into the accused interest in passing the sentence?
The question of the Justice Ball that mentioned there is partly an empirical question. I take your point about the accused interest, but if we want to know whether the person will be reformed, you don't listen to the counsel's plea mitigation, and you don't necessarily listen to what the offender says with all the best intentions. What we are trying to do now, and what our council is doing for the first time in Victoria, and it's happened in some of the other jurisdictions, is we are now, as I said this morning, collecting data to see what effect different sentences have on reoffending. So it's not what you say or what you say. What we find in our preliminary data is if you hold all other factors constant, for example, we know if you've got more prior convictions, you're more likely to reoffend. The seriousness of the offence, age, gender, all those things. We've done some very sophisticated statistical studies, and we've tried to separate the effect of the sentence on reoffending. And we find, unsurprisingly, even taking into account prior convictions and everything else, balancing those out, prison is the worst place to put people. Everyone knows that. It's a university for crime. So the reoffending rates are very high. In fact, binding over or bonds or fines are less criminogenic. We need to know what the effect of sentences are, and this is what we're doing by having a database, which is not what the courts can do, it's not what anybody else can do, not what a single academic can do. We're now trying to find out what sentences work and what happens. That's the kind of information you want. I agree you need to get the perspectives of offenders, but we can do that through the consultation process, not in court. To answer all of your questions, I hope, what you need is even if your system is working well, it is not perfect. Any system needs continuous introspection, reflection and improvement. All those reports you saw us do were dealing with particular problems in a reasonably well-working system. Our system is not broken. Your system is not broken, despite some of the criticism, but it's not perfect. And any good political system, any good judicial system needs constant reflection and renewal, and a body that has resources and the time and the legitimacy to do that can constantly renew so that you get a better system. So it's not a question of, please, just guidelines. If anything, I make this plea, don't become obsessed by this. The system is more than guidelines. It's about what sentences work, who they work for, what kind of options should you have. Should you have restorative justice? Should you have drug courts or family violence courts? How do they work? What should you do? There are 100 questions you could look at. Guidelines are just one. And it's important that you embark on systemic reflection and systemic renewal. That's my final plea to you. And I just thought of one other answer to the question before. I have spoken in Hong Kong, where again, to a room full of people saying, why do we need a council? Again, it was one or two people who said, it's a good idea. I've been to Scotland, where again, a few people said, we want to revive our council. Because of the same thing, we don't have a broken system, but we don't have a perfect system. Let's work on a mechanism to make it work better.
Just to address your concern, in United Kingdom, there is a provision. If it's not in the interest of justice, despite of the guideline, the court did not follow the guideline. So, for example, say in a case that you have a client who committed a crime, and there is that guideline to say, okay, the minimum is, what, and then the maximum. If you can convince the court that no, this is not an appropriate case to follow the guideline, or for example, that it's an appropriate case for the court to bind over your client, then in UK, the court will not follow the guideline.
Thank you, Jato. Ms. Shaina?
My question, the first part of my question is addressed to Yang Arif Dato' Azhar. Could you revert a lot about how, the different factors you have to consider in sentencing? I was wondering if you could tell us how important is mitigation to judges? And I ask this question specifically because there are a number of cases that have been reported. Serious cases, not simple theft cases, where the accused has been unrepresented. Last year, there was a case of infanticide. Just last month, there was a case of the Indonesian maid who held the baby. That video that's on YouTube, it's very graphic, and I think very few Malaysians have complained about the sentence or were even concerned that the woman was unrepresented. We always complain about slow justice in Malaysia, but that must have been one of those swift cases because she committed the offense on a Friday. By Tuesday, she was prosecuted, convicted, and sentenced. She pleaded guilty. Her only thing in mitigation was, "I'm sorry." So I'm concerned about, is there a right to legal representation in Malaysia? Is it a practice that our judges think is important? Should prosecutors raise the question there should be legal aid or, lawyer from the Bar Council's legal aid center, since we have a National Legal Aid Foundation now that does not cover foreigners? In cases like the infanticide, if you're unrepresented, should the judge have, before sentencing, at least ordered psychological evaluation? And for Prof. Friedberg, you talked about that the sentencing council is not just about tariffs, but about processes as well. Is right to representation an important process to ensure justice in a criminal justice system?
Quickly, I think definitely mitigation advanced by an offender will have a bearing on the way the judge or the magistrate is going to pass an appropriate sentence. Because and when mitigations are advanced, especially through a counsel, there will be more information for the judge to consider. There will be extenuating circumstances. What are the factors that induce, for example, the offender to commit a crime, right? This definitely will have a bearing because, as I mentioned in my presentation, that when a judge considers the sentencing, he will have to consider all the relevant mitigating factors. And one of the important mitigating factors that we do think that the extenuating circumstances, why he committed the offense, And we thought a good mitigation definitely that would influence the judge, as opposed to the address by the prosecution when the prosecution addressed the court on mitigation. And herein lies, I think, what I said just now, that why I think a guideline is very important, perhaps in magistrates court, because most of the cases in the magistrates court, lower court, they are not represented, and they will not be able, an offender will not be able to give a proper and effective mitigation for the courts to consider. These are my views.
You asked me whether I think legal representation is important. I think it is, but it's not something that our sentencing council has looked at. One of the important things about a council, especially under a statutory remit, is that we are very careful not to exceed that. So we don't look at bail, we don't look at policing, we don't look at substantive law. We're very careful to stay within the boundaries of the legislation. So our job is sentencing. Unless legal representation falls within the question of sentencing, which it does incidentally, we wouldn't be looking at that per se. So it's another caution that whatever you set up should stay within the boundaries of what it's required to do. And it's easy then to bleed over into other issues. And every now and then we've had to say, this is a substantive criminal law issue, go to the Law Reform Commission, which we have in Victoria.
Just to answer part of the question that Charlotte posed. At the moment, so far as legal representation is concerned, for capital punishment cases, you have the list of assigned counsel. Then you have everything else. For Malaysians, we have the National Legal Aid Foundation, which is reaching out, is coming now next month in April, a one-year anniversary of the National Legal Aid Foundation. We reach out to about 60-70% of the remand cases, almost halfway mark, just beyond that for the trial cases. The problem with the National Legal Aid Foundation, of course, is the low rates of payment for the lawyers. the AG, as chairman of the foundation, has agreed in principle to look at revising rates, largely because the Prime Minister increased the allocation announced last year for this year from 15 to 20 million. So with the increase of the rates, we hope that the penetration of representation will widen. So far as representation of non-Malaysians is concerned, that is something we're looking into so far as capacity building and resources, because we don't have lawyers at every single courtroom standing by ready to jump in to represent the accused. That is something we will consider, and we hope through time the National Legal Aid Foundation can be expanded to also allow for representation of non-Malaysians, but that will take time. So far as issue of migrant workers is concerned, we have been in engagement with the ambassador for the Indonesian embassy to actually volunteer as and when Indonesians are caught up in the criminal justice system. If they require legal representation, we will step forward. And the specific case concerned in Kuantan, she's actually at the moment represented by a lawyer. It is pending appeal.
Just to add, sometimes when cases come before courts, you would have seen some, even magistrates, usually sessions courts, when it's a fairly important case where you're going to sentence someone 20 years or something, if she's not represented, it's quite easy to ask some member of the bar to sort of stand down the matter for a few hours and then ask to mitigate, because you know the severity of the sentence. If you're going to pass that sentence, that could have been done and should have been done, otherwise there's no criticism. But I'm proud to say that as far as the amendments to the CPC, especially section 172B in case management, it is the bar which inserted and in fact spoke to the AG in consultation with the judiciary, where we wanted this provision added that for trials, the court must assist the accused who is underrepresented to appoint an advocate and solicitor. That has been made a statutory requirement, and that was put in by the bar.
We will probably have to further amend that even a person pleads guilty, before the sentence is meted out, should be represented. I think that would be an important thing to bring up to the AG. Right. Any other questions before we call it a day? Anyone else? If not, we end the dialogue session. Okay, if there's no other questions, I would like to thank Yarif Dato' Azhar Muhammad, Professor Arif Iqbal, and Dato' V. Sidamaram for this question and answer session. And I would like to invite the President of the Nation Bar, Mr. Lim Chivi, to give a token appreciation to Yarif Dato' Azhar and Dato' V. Sidamaram. Thank you, ladies and gentlemen.
Ladies and gentlemen, that concludes our session for the day. Tea will be served at the pantry, so can you please help yourselves? Thank you very much.